United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, please be seated. Please be seated. And counsel, when you're ready to start.
Please be seated.
Judge, hold on one moment. We have an issue with sound.
Okay.
Can you hear me on the chat? Can you hear me, please?
I can hear you. Can you hear me?
Thank you, Judge. Yes, sir, I can hear you.
All right.
Can you push the button again, Jocelyn?
Push.
Yep.
All right, Mr. Vanguard, when you're ready. I don't think I'm being heard.
Judge?
Sarah?
Yep. Just give us a
I
second,
do not
please.
think I'm being heard.
Push the button one more time, Jocelyn, to make sure it's not that. Judge, can you say something?
Yes.
Okay, push the button again.
Okay.
Lana, can you hear me?
I can hear you.
Okay, Judge, I'm working with some of the IT team just really quickly. Give us
can't
just a
see
moment, and I
anybody.
apologize. I've
Can you hear me now?
No, just wait a second, Judge, please. Hit the button again, Jocelyn. Hello?
Sarah, can you hear me?
Yes, sir. Can you hold just a moment, please? Sorry for this. Is it a bit of an echo now, Lana? Lana?
Can the courtroom hear me at this point? No, apparently not.
I'm sorry, Judge, I didn't hear that last thing.
Lassie, bring me the telephone, please.
Judge Wilkinson?
Yes.
Just give us just a moment. We have the network manager coming over. Thank you.
How long is this going to take? Thank you. Thanks.
Is there an echo now? That's it. Leave it there.
Can you hear me?
Yes, sir.
Can the courtroom hear me?
No, the courtroom cannot hear you. It's an issue with the sound that is in the sound system. So bear with us just a moment.
Sarah, let's get started. And I will, you all fix this problem, but let's get started. I don't want to delay it anymore, and I'll just participate by listening until you get this straightened out.
Yes, sir.
But let's proceed. Sarah, let's proceed.
And we'll be working on it in the background, and he's gonna just listen for now.
Can we call him?
We could call him from the courtroom deputy.
Yeah,
phone.
let's call him.
Or can we
Judge
call him
Harris,
from
can
the
you
Zoom
hear me?
conference?
Can you hear me, Judge Harris? Sarah, please proceed with these, go forward with these proceedings and fix this.
Pardon, I'm sorry, Judge. I took myself.
Tell Judge Harris
No one
to
can
call
hear you.
counsel to the microphone.
Yes, sir. Yes, sir. Just bear with me one moment because they're gonna call you, okay? I'm gonna call you from Zoom. And no one can hear you but me. Can you please give me that number? Good.
Sarah, tell Judge Harris to preside and to proceed and get this straightened out, okay?
Yes, sir. I can fix so you can speak if I call you on your phone. May I have that number very quickly? Nobody can hear you but me.
Can anybody hear me at this point?
No, she says she's the only one who can hear you. That's.
I'm the
why
only one who can hear
Tell
you.
that number so she can call if somebody needs to call you.
What number do you want?
This
Well,
one.
the phone that's right near you.
Okay, call.
Hold on one second.
Okay, Nicole's saying to hold on. Can you speak, Judge?
What?
She says to speak.
Well, 1, 2, 3.
Judge, we can hear you now. We're good.
Okay.
We can go ahead and start.
All right, let's get started, Mr. Vanguard.
Thank you, Your Honor. May it please the court, my name is David Bungard. I'm here on behalf of the appellant in this case, Mr. Jeffrey Reed, and there's several issues we'd like to ask the court to consider today. The first issue concerns, we believe the district court erred in denying Mr. Reed's Rule 29 motion for judgment of acquittal on count 1 that it charged Mr. Reed with a violation of 18 United States Code 1521, where the false lien that was prepared and filed by Mr. Reed was against a pseudonym name of T.L. Blake, as opposed to the actual name of the Internal Revenue Service officer who was actually working his collections case. The language of the statute is pretty clear and unambiguous. The criminal liability for this offense attaches to only false liens that are filed against individuals described under 18 United States Code Section 1114.
Or attempted to be filed against an individual, right?
Correct, Your Honor. Correct, Your Honor. But that class is very limited. It only covers federal employees or officers of federal agencies. There's no coverage for criminal liability for false liens filed against private citizens, state employees, or fictitious persons. And the government essentially conceded that point when they charged this case as an attempt offense.
Can I ask you, I read the statute the same way you do. I don't think it covers fictitious persons. But it seems that this lien was filed against, there is a real person. And we know that because the real person tried to get a mortgage and was told that she couldn't because of this false lien. So there's a real person out in the world against whom this lien was filed.
Well, Your Honor, to the point that I would go to in terms of a previous court decision that this court made in United States versus Haas, where this court defined, actually looked at the definition of what constitutes an individual and found that it did not apply to a fictitious name, a fictitious person.
And I, as I said, I'm starting from the premise, at least for the sake of argument, that this statute doesn't apply to fictitious people. And in Haas, there was no person. It was an entirely invented person. Here, there is a real person. Your client got the name wrong, but the person is the person.
I'd ask the court to consider the reason why this statute is in place is to protect actual employees who get liens filed against them, not fictitious names. What the IRS has done here is basically created a mechanism that protects their employees from having this ever done to them. And with respect to Terry
But
Schiff,
it was your client's counsel, it was your client's activities that necessitated the the use of a pseudonym. That it was for her own protection and for her own safety. She had to use the pseudonym, and it was your client's misconduct that led to that.
Well, Your Honor, as the government points out, the IRS has been using pseudonym names since the mid 1990s. So this is something that they have done for a long time. And the actual statute, when I looked at it, for the false lien statute, was passed in 2008. And I would submit that if Congress had intended to provide coverage for fictitious names, that they would have included that within the definition for individual. But in this case, there was no real or personal property of Terry Shipp that was affected by this lien. The lien was filed against T.L. Blake, which was a fake name. There was no IRS employee named T.L. Blake.
Didn't she testify that when she tried to get a mortgage, this was a problem?
What she testified to, Your Honor, was that she had applied for an application to get a mortgage, and she had to list her alias names that she worked under. And it was during that they ran a credit check, and she said she had to file some letters to get it done, but there was no testimony that it prohibited her from actually getting a piece of property. This was what she had to put up was basically the harassment that this statute was meant to avoid. But again, there was no real or personal property of hers that was ever affected by the filing of a lien against T.L.
Did you
Blake.
say what she had to do was put up with the harassment that this statute was intended to avoid?
Correct, Your Honor. That's what this statute was meant to prohibit people from filing things that affected the actual property of judges, federal employees, and others that are protected within that system. But we believe that Mr. Reed should have a legal impossibility defense here, to the extent that the acts that he tended to do, if followed through completion, would not be a crime. So to the extent that filing a false lien against a fictitious name is not a crime. This court recognized that defense in the Hamrick case and recognized that it didn't apply, but I would submit that it was because of the facts of that particular case.
Can I ask you just a question? Did you object to the jury instruction on this?
The jury instruction
For count one?
for count one.
Did you ask for instructions about the whole fictitious person theory?
We asked for an instruction that it had to be an actual employee, but I don't remember the specific language of the instruction that was given.
But you didn't.
That had to be a real person.
So is there an objection somewhere? Like,
I don't believe there's any objections on the jury instructions. We made this objection on a Rule 29 motion
Okay.
to the legal issue, Your Honor.
Okay.
So in that regard, there's circuits out there. There's two circuits out there that have recognized the legal impossibility defense, the Third Circuit and the First Circuit, to the extent that in the Hisu case that I cited in our brief, there was an underlying case of Berrigan where a defendant had been convicted of trying to conceal mail, getting out of a prison without the warden's consent, but it turned out the warden actually knew about it. So what the defendant intended to do really wasn't a crime. And the other circuit that we cited was the Fernandez decision out of the First
This isn't
Circuit.
really legal impossibility, is it? I mean, it kind of goes back to Judge Harris's point that your client tried to file a lien against the IRS agent who was trying to collect. And if he had succeeded in doing that, it would be a crime. The reason that he didn't quite accomplish what he wanted to was a factual problem, right? He got the name wrong. He used her work pseudonym. But if he was trying to file a lien against a real person who was causing him a problem from his perspective.
If the IRS agent had used her actual name, that would be correct. But again, it's our position that using a fictitious name is outside the scope of the definition for an individual.
So your position, to follow on the comment that Judge Rushing's made, your position is that the IRS is never allowed for purposes of this statute, to have an agent adopt a pseudonym, no matter how obstreperous, no matter what the kind of threats against that person are, that they just have to sit back and endure it and use their real name, and by using their real name, subject themselves to even more abuse. That's your view, right?
No, Your Honor, what I'm saying is that there's nothing wrong with the IRS using pseudonym names. The problem is that I think that this is the first case that I'm aware of, when in all the research that I've done on this issue, that the government has ever proceeded to charge someone for filing a false lien against a pseudonym name as opposed to an actual name of the person. All the cases that we've cited in the past have all involved actual employees and real persons, because the lien itself is only effective if it actually names a real person. A lien against T.L. Blake does absolutely nothing to harm anybody, because T.L. Blake
But
is
the point is, this is an attempt charge. It seemed to me settled law that factual impossibility, and here the factual impossibility was simply the use of a pseudonym, but factual impossibility is simply not a legal, not a defense to a crime of its account. And that seems to me that is a very settled proposition. I'm surprised. What was charged was an attempt crime. And the only thing that prevented it was a question of factual impossibility. The fact that the IRS, for good and sufficient reasons, tried to protect the safety of its agents, all that prevented the attempt from being consummated. And the use of the pseudonym is simply created factual impossibility. And that isn't a defense against an attempt crime. That's really, it seems to me that's straightforward.
I would agree that, Your Honor, the courts have found that attempt is not a defense to the factual impossibility offense is not a defense on an attempt charge. Again, our position is that a legal impossibility
Then
defense.
why isn't the use of factual impossibility, create factual impossibility?
I didn't understand that. That didn't get the audio on your comment, Your Honor, didn't come through, but I need to proceed to some other issues if I could. The second issue that we'd ask the court to consider, we also filed a Rule 29 motion with respect to count 2. And that was where Mr. Reed was charged with, under the omnibus clause of 26 United States Code 7212A, with impeding and interfering with the administration of justice, or the IRS's administration of the Internal Revenue Service Code. The Supreme Court's decision in Marinello limited liability under that type of charge. Specifically, there has to be a nexus charged between the conduct and the particular administrative proceeding. And the court was pretty clear in Marinello that that this isn't a catch-all for every potential violation of the Internal Revenue suit.
Sorry to interrupt, but can I take you back to the jury instructions again? And the jury was instructed on exactly that, and there was no objection, because it's exactly what you're saying. There has to be a nexus. It can't be just day-to-day routine work. I mean, basically read the case into the jury instructions. So your argument is that the jury was properly instructed on this, but there was not sufficient evidence from which it could have found the necessary nexus?
It's a legal argument, Your Honor. Yes, that given the type of conduct that was involved here, that this was just a general collections actions, a run-of-the-mill collections actions.
Was instructed, if it's a run-of-the-mill collections action, that's not enough. But so this is a sufficiency challenge.
Correct, Your Honor. Correct. Yes, and this was brought before this matter was sent to the jury. But again, our position is that this was a run-of-the-mill collections actions that was not the type of administrative proceeding that was anticipated by Marinello. Mr. Reed has never been audited by the IRS. He was never investigated for reasons why he wasn't paying taxes. He was not charged with any crimes for failing to file any tax returns. As we mentioned in our reply brief, if you look at the IRS tax data book, in 2020, the number of notice of levies that were filed against third parties that year by the IRS was 396,000. That averages almost 1,000 a day, the types of notices of levies that T.L. Blake sent to the Holiday Inn Lodge to garnish Mr. Reed's wages.
Counsel, why wouldn't a jury be entitled to find that this was something more than a routine sort of than routine IRS activity? Because the Marinello opinion gives examples of just a routine investigation or an audit or normal IRS review. But wasn't this something more when the activities here in terms of the liens required the IRS agent to garnish wages and travel to West Virginia and do a whole lot of things that are beyond routine IRS activities? And the question I have is, if as Judge Harris correctly says, this is a sufficiency question, then why couldn't the jury find that there was a sufficient evidence of nexus and that what was involved was considerably more than the day-to-day routine of IRS employees? This woman had to go to extraordinary lengths, both to protect herself and to collect the taxes. And why couldn't the jury see it that way?
Your Honor, we're getting ready to run out of time. Can I proceed to answer that question?
You quickly, because you've reserved some time for rebuttal, and I want to make sure you get that.
Thank you, Your Honor. Ms. Shipp testified at trial that this was part of her day-to-day duties, that basically what she did 40 hours a week was work on debt collection from taxpayers that owed money. Her involvement in this case, basically, she sent letters out to people telling them to pay the garnishment, and if they didn't recognize it, then she'd followed up with a visit in person to make sure they did it. When the one check was paid, when she got a letter from the hotel that said Mr. Reed was no longer employed there, she basically closed the file and went on to the next case. So there was nothing special in terms of what this agent.
All right, counsel, I understand that, but that's a jury argument, and the jury wasn't required to credit that view of things. It's not, this isn't a question, it's a sufficiency question, and the jury wasn't required to credit that particular description. But at any rate, counsel, I want to make sure you have some time for rebuttal. Can you take up some of these matters when you come on for rebuttal?
Yes, I will, Your Honor.
Thank you. All right, let's go with Mr. Goes. Hear you, sir.
Thank you, Your Honor. May it please the court, Eric Goes on behalf of the United States. Reed's conviction and sentence should be affirmed in this case. Reed intentionally filed a $5 million fraudulent lien against a revenue officer. She was a real person. She testified under her own name. She was permitted to use an agency pseudonym. And 1521 was specifically designed and passed so that judges, prosecutors, and federal employees are not to be targeted by liens. And the targeting is broad enough with the inclusion of the words attempt and the inclusion of the words conspiracy that it does not have to be successfully completed. The intent alone is enough to complete the act, and that's exactly what he intended. He intended to target this specific revenue officer. He knew she was a revenue officer, and he targeted her specifically for the course of her conduct. He made a mistake. The mistake was a mistake of fact. He got the name wrong because she is permitted to use a pseudonym. That wasn't something she made up. That is a governmental policy to protect agents, and specifically, she was in the ATAT group, the Abusive Tax and Avoidance Transaction Group. So the case had already been through regular channels in trying to collect the back taxes from Reed. And that's where she kicked in. And the efforts that she made were extraordinary. But the use of the pseudonym does not give him a free pass to just file fraudulent liens. Now, we don't necessarily have to show the harm, but there was.
Well, the pseudonym, the use of the pseudonym could defeat this kind of claim if the pseudonym, for example, wasn't tied specific to a specific individual, could it not?
Yes, Your Honor. And taking Judge Harris's point, if this is not including fictitious or entirely made up persons,
Yeah,
then
what you're saying is there's a difference between a pseudonym, a fictitious pseudonym, and a fictitious person.
that's right, Your Honor. And in this case, the evidence was clear, certainly beyond a reasonable doubt. She was a real person, and she was acting in the scope of her duty. She even explained why she was using the pseudonym. So this fits squarely within an attempt, and that was the intent, to avoid the harassment and avoid the transaction.
Counsel, so just so I understand, so the government, as you see the case, there was just an attempt here. There was no completed crime.
We charged it as an attempt out of an abundance of caution for the exact fear that this, well, I don't want to say fear, but the concern this court raised. If it was a completed act, we didn't want to necessarily say, well, aha, this works. And we, upon reading this court's decisions and attempt law and the jury instructions,
Yeah, I'm
we
just
thought,
trying to figure out whether, because there was this thing where I think you were about to say she did testify to actual harm. I'm not trying to push you on anything. I'm just trying to figure out, in this case, like the pseudonym, it turns out it provided somewhat imperfect protection.
Your Honor, we analyzed that, and there was at least one theory where we could have treated this as a completed crime.
Okay, but you're going with the attempt.
We went with the attempt crime because we thought that more accurately captured the conduct, and it also solved whether this use of a pseudonym is a means of identification or an individual. We knew clearly she was an individual. Now, I'd like to turn a little bit to the Marinello nexus. Well, I'm sorry, I want to make sure this was a factual mistake. He thought that was her name. He targeted her specifically for that name. It clearly was a factual mistake. A legal defense doesn't apply here. This law had not been repealed, and that's pretty clear that he intentionally targeted her, making a factual error. Legal defense is not available to this.
Can I ask you just one other clarifying question on this first point? Is this a statutory construction question that we're reviewing de novo, or is this a sufficiency challenge on the first count?
Well, actually, I guess it's a hybrid of that, Your Honor. It is going to be an issue of statutory construction, which the court does review de novo. But in terms of a sufficiency challenge, the jury heard whether this person was an individual. As the court correctly noted, they were instructed as to what an individual is. There was no objection to that instruction. I double checked before I got behind the podium, and that in itself would have at least been a factor for the jury to consider. But again, she testified as a real person, and she was not a fictitious.
But the nexus question is a sufficiency challenge, isn't it?
Yeah, yes, Your Honor. Again, under the framework of the court is going to review the statute itself, but the Marinello standard calls for nexus. In this case, the principal evil of Marinello.
It's a little thing I can probably figure out on my own, but maybe you can help me out on it. So I agree with you that on count 2, this is obviously just a sufficiency challenge. The jury was instructed properly, and now the question is, was there enough evidence from which the jury could find, as it was instructed, that there needed to be a nexus? Why is the first count different? Was there like an objection to the jury instructions?
To the first count?
On the first count, yeah.
There was not an objection to the jury instructions. We did have a pretrial hearing where this argument was raised, but there was not an objection to this jury instruction that I could find. I checked hastily. I
guess I wonder why the first one isn't just a sufficiency challenge too. I mean, the jury was instructed it has to be an officer or employee of the United States. The jury found it was.
It well could be, Your Honor, but as you framed your question to me as a question of statutory interpretation, I knew the answer to that is a de novo review. So
I was okay.
So I did not want to mislead the court. But let's talk a little bit about the nexus. The defendant admitted the nexus. When he gave his statement to the agents, he specifically told the agents he filed the lien against the IRS agent for the purpose of preventing the IRS from collecting the taxes. The principal evil of Marinello is satisfied. As to whether it was a routine collection activity. The agent said it was a targeted investigation. And that's what Marinello calls for, a targeted administrative action. Now, those are the words she used when she testified, a targeted an administrative action. But what this court's going to look to is not what words we use. It's what was her conduct. What did she do? She sent the letter. He sent it back, refusing to pay yet again. Remember, he owes hundreds of thousands of dollars in taxes. They've been trying to collect for him for years. So then she travels to West Virginia. She walks through the garnishment process. Reed tries to thwart the garnishment process by demanding that the hotel owner send a letter on his behalf. She refuses. The hotel owner actually calls the agent. So this is far and above the normal routine day-to-day work, such as preparing or reviewing tax returns. So when Justice Breyer wrote that example of review of tax returns, that was the example he set forth. This is so much more than that. And like the Graham decision from the 11th Circuit, their language is just perfect. So this is not a borderline case. That's what they said in Graham. This isn't a close case. There could be a close case where an innocent taxpayer sends back a letter or something like that. That's the evil that Marinello is designed to prevent.
How many returns are there? How many are there? Any tax year?
Respectfully, Honor, your question broke up.
How many returns are there?
How many returns were there?
How many tax returns were there?
He had not paid taxes since 1995. So the case dated all the way back to 1995. Now, we were precluded from introducing some of that because the district judge thought he didn't want to risk a 403. So some of that was blacked out. But there's at the very least in U.S. Exhibit number 3, a letter that says since 2013, they'd been specifically targeting him as a targeted administrative action to try to get him to pay taxes. But Your Honor, he had not paid taxes since 1995. So I guess the specific answer is all the way back to 1995. I want to make sure I've answered the question. So we cited the Graham case. We cited the Preligar case also as support for what constitutes non-borderline cases. This defendant's conduct is not borderline. It was an exceptional activity from the IRS. His abusive conduct in trying to obstruct. And again, the notice of levy, the opportunity to cure. I wanted to specifically highlight not only the $5 million fraudulent lien that tried to take all of the agent's property, exempting only her photographs, wedding rings, and survival rations, whatever he meant by that, but also the $9 million copyright that he sent to her. And remember, he didn't just file this lien against her. He also sent the notice of default, the opportunity to cure, to her supervisors at the IRS. He sent information to various bonding, the insurance commissioners in 4 different states. This was all intentionally designed as a months-long harassment campaign specifically against this agent and also the owner of the hotel, all designed to thwart. So this fits 26 USC 7212 like a glove. This is exactly what that statute is designed to prevent. And like Graham, like Preligar, this is not a close case. There could well be a close case, but this is not a routine review of tax returns. And the reason is because of Reed's conduct. And finally, I wanted to turn a little bit to whether
I'm sorry,
Your Honor.
No problem. The defendant seems to interpret Marinello to mean if this is any agent's day-to-day work, that Marinello means it's routine. That uses some of this language. It's not the day-to-day routine work. And she testified that in this special division, most of what she does is this sort of work. Do you think that's what Marinello means? And what's your response to that?
Well, her testimony and cross-examination was she said this was a targeted administrative investigation, and she said this was her day-to-day activity, but that was her day-to-day within the abusive tax and avoidance transaction group. So the case had been transferred, Reed's case, to specifically try to collect taxes from someone they knew was going to subject them to harassment or to targeting. So that part of it could well be a factual determination for the jury to decide whether this is routine day-to-day work. But our response would be what her specific conduct were the facts in this case. And the facts in this case show that this was not just a routine day-to-day collection. How she
Not routine tax collection for the agency, even if there are special employees who are specifically assigned to handle the difficult abusive cases, right?
That's right, Your Honor. And we're not asking for a bright line rule. For instance, if she had just sent him the letter and that had been it, perhaps that would have been closer to the concern that Marinello was raising of what's a review of tax returns. But again, we're not there on this case. This isn't a close case. It wasn't just the review of tax returns. It was the letter. It was coming back. It was
And how could it, counsel, how could it be just a routine review of tax returns if there are no tax returns?
They had what the IRS had done in that case, Your Honor. And I've got to be careful because this is a little beyond the record, but what they had done in this case was they had come up with estimates and tried to recreate some work history for him. Again, we did not put that on the record in this case. We were not permitted to. I did want to turn to whether the district court didn't commit clear error when it applied 3 enhancements. There was an intent to carry out a threat. That was the enhancement directed against the agent. There was a threat to damage the property, and there was extensive planning and preparation. The 2-level enhancement for extensive planning and preparation is frankly pretty straightforward. The district court didn't commit clear error to show this defendant's months-long campaign harassment, which required letters, physical preparation, mailings, looking up who the supervisors were at the IRS, double checking some of this lien language. It takes a while to just even physically figure out what he's talking about. So this is extensive, and it's certainly not clear error to show that it showed effort, research, and planning by him. And in terms of the Reed's conduct to damage property, I wanted to turn to that briefly. Property damage can be more than physical property damage. That issue was raised, and that's kind of an issue of interpretation of the guidelines. It's physical injury to a person, comma, or property damage. Now, when you turn to the comment, it doesn't define property damage other than it says it can include cause or threaten to damage property. So the Reed case from the 8th Circuit is on point, and it's a tour de force of explaining liens and how liens can damage property. And it cites the Permanent Mission of India case, which is the United States Supreme Court saying, dadgummit, liens damage property. Liens are property damage. So when this court applied that, he's applying fairly settled law, the Supreme Court, the Reed opinion, to say this 8-level enhancement. And finally, Reed
It's not like, I think you would agree, or maybe do you agree? It's not sort of the first thing one would think of in this context. You'd think of more like, do it or I'll burn your house down, not do it or I'll file a lien against you.
That's right, Your Honor. In fact, I even put that on the record. I commended the probation department for thinking of that, because I was thinking physical damage as well. And sometimes the probation department spots things we don't. And they were right. And I don't want to say I was wrong. I didn't object to it, but they were spot on. And again, I have to train myself to read about liens, and some of that can get very technical. But again, I can defer to the United States Supreme Court and the many page opinion in Reed explaining it all and saying X equals Y equals this enhancement applies. Regardless, the district court didn't commit clear error in applying it. Finally, threats can be broader than a physical threat. The court applied a 6-level enhancement. When he applied that 6-level enhancement, the Jordan case is nearly on point to the facts of this case. And the 4th Circuit in the Gary opinion has specifically held, that because threat is undefined, it can be broader and it can include conduct before and after. The district court found
all of this, counsel, all of this is subject to a clearly erroneous standard of review. I mean, whether something is a threat or whether it's not, some cases, yes, it's a threat. Other cases, no, it's not a threat. But this is the standard is plainly a clearly erroneous standard. And it was, after the district court be clearly erroneous, the agent certainly perceived it as a threat. And if, the whole idea is if you don't back off, we're going to throw more liens at you. And that was perceived as a threat. And of course, these things inflicted property damage because the liens are widely recorded. Creditors research them. Creditors deny loans and all kinds of things because their liens outstanding. And that's the whole purpose of the lien, is to inflict damage and to threaten further damage if the tax collector didn't desist and back off. And it's all subject to a clearly erroneous standard.
Yes, Your Honor. And that's exactly what the district court did in this case. And that was exactly Reed's intent. And nevertheless, Reed still received a below guideline sentence from the district court. The district court was correct. This defendant was a paper terrorist. He specifically designed to target the owner of the hotel and the tax collection agent in this abusive retaliation scheme. We think the conviction was exactly correct. We think the enhancements were exactly correct. We would ask this court to affirm both the conviction and the sentencing in this case. Thank you, Your Honor.
We thank you. And counsel, Mr. Bungard, you have some rebuttal, and we'd be happy to hear from you in rebuttal.
Thank you, Your Honor. I first want to start, I believe I misspoke to one of Judge Harris's questions in regards to TL Blake. The purpose of the false lien statute is to protect federal employees who gets liens filed against their real or personal property. In this case, it doesn't extend. I think that it would be an oversight to say that extends to protecting federal employees who go out and try to apply for property, and they have to they're asked if they've ever had a pseudonym name they've used in the past. I don't think the statute was meant to cover that. It was only meant to cover it's real and personal property that the person actually has, not something that they may go out and buy in the future. So to that extent, I just wanted to make sure I was clear on my point. The remaining arguments that we have, and again, this is under the presumption that if the court finds that an attempt can be made, that an attempt prosecution can be made in this case with the pseudonym name, that there were still 3 errors that were committed in the guideline calculation that was done by the district court. And with respect to the first error, I believe the district court erred in the interpretation, in the legal interpretation of the guideline under 2A 6.1B1 in providing a 6th offense level enhancement for engaging in conduct evidencing an intent to carry out a threat. The court based this upon the copies of documents that Mr. Reed had actually sent to the IRS before the actual lien got filed in circuit court. To that extent, all those documents that were sent to the IRS basically said the same thing with respect to how TL Blake was named. And I think it's important to note that Mr. Reed had no personal interactions with TL Blake. She never picked up the phone and actually had a conversation with him, never met him in person, but her name was on everything that he saw. That's the only reason why he used TL Blake. But if she had done what you suggested, would that not have subjected her to even more abuse and harassment? She used the pseudonym name that she was allowed to use by the IRS. There's no question that she used that name and not her real name. But the issue is that all of those documents contained information or allegations with respect to TL Blake, not Terry Shipp. So the fact that he was claiming he was going to file a lien against this fictitious person, it was not a threat against any real or personal property, because TL Blake, the name TL Blake, does not have any real or personal property attached to it. And again, I think with respect to this guideline enhancement, the whole purposes of having offense level enhancements are to punish persons who commit conduct that's aggravating, or basically, in this case, this was not a completed offense. So to that extent, that it was an attempt, that there was no intent to carry out a threat, because the documents that he sent to the IRS ahead of time did not contain any threats against any particular person, only that fictitious name. Well, the threat can be an implied threat. It doesn't have to have some sort of quid pro quo language that if you do this, I'm going to do that. A lot of threats, and some of the worst, are implicit, but the question is, it's all factual, and is there some basis for the district court's view that this was a definite threat? I don't see how the IRS agent in this
case could have reasonably perceived it as anything other than a threat.
Actually,
was
Your
the
Honor,
whole- that was
I
the
think the
whole-
record states otherwise. I think if you look at what happened, when these documents were sent and received by Agent Ship, she took no action against Mr. Reed. All she did was basically put him in a file. There was no,
I remember in the transcript, this is exactly the argument you made to the district court, and the district court was like, no, like this is very speculative how they treated it. And this just sounds like a factual argument that you made to the district court that the district court rejected. And I guess, I mean, there's nothing wrong with making the same argument now, but now we have this very, generous standard of review when it comes to a factual determination by a district court that no, these actually did constitute threats.
well, and I guess I go back to that the documents themselves did not contain a threat because it wasn't threatening specifically to Terry Ship. It was to this fictitious name, T.L. Blake. And the second argument that I have, and I'm running out of time, Your Honor, if I could proceed with your permission.
Yes, please proceed.
The other error with the base offense level calculation was with respect to the count 2, the +8 enhancement under 2J 1.2B2 for, again, threatening to cause property damage. And again, the same argument I would make here is that if the government is proceeding with an attempt theory here, there was nothing, the government presented no evidence at sentencing that there was any particular real property or personal property of T.L. Ship that had.
Counsel, someone has a property interest in their own being. And what you did was by filing these liens, you limited the amount of flexibility and the freedom that this individual possessed to get loans and everything. You subjected her to scrutiny by creditors and everything, and that's a property interest that's plainly damaged by the filing of these liens. Nobody I know has advanced the argument that a lien enhances the value of property, and in this case, it limited the freedom of the agent to engage in all kinds of financial transactions, because the creditors that are looking at those liens, they don't know the whole background of this. They just see the final bottom line, which were that liens were filed against this individual. And that's a red flag for creditors. They don't have the time to investigate why the lien was filed or what purpose was filed. The creditors, banks, loan officers, they just say, whoa, no, here's this lien on file. It's a red flag. And then they're going to not advance the loan. So that is acute property damage, and any individual that has liens slapped on them, particularly liens of this nature, would tell you in an instant that it diminishes their commercial freedom to engage in transactions to which they are entitled to engage.
Your Honor, just to respond again, that the name that was used in this case was not Ms. Ship's. She used a fictitious name, and that there was it's our position that at sentencing and throughout the whole trial, the government did not present any evidence that any specific real or personal property of that T.L. Blake, that name, was ever harmed, damaged, or threatened to be damaged.
All right, counsel, thank you very much. If either of my colleagues has any further questions, we can wait. Otherwise, we want to thank you and Mr. Goes for your argument, and tell you both how very much we appreciate it.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. May it please the court, George Piemonte on behalf of the appellant Brian Pepper. This is a case from a Social Security disability claim in which the administrative law judge has committed at least 2 errors that would warrant remand for a new hearing. Excuse me. The first involves an opinion questionnaire filled out by Mr. Pepper's treating gastroenterologist, Dr. Kandikar. I believe I'm pronouncing that correctly. The ALJ found Dr. Kandikar's opinion persuasive, except for one portion of it, which he has the right to do so long as that rejection of that particular part of his opinion is supported by substantial evidence.
So which part of his opinion do you think the ALJ rejected?
The part she rejected was where Dr. Kandikar stated that Mr. Pepper would need 2 to 3 unscheduled bathroom breaks lasting on an average of about 15 minutes.
So that is not, I'm glad we're getting here quickly because I understand that's sort of the main premise of your argument. And that's just not how I read the ALJ opinion. I thought the ALJ did incorporate that. That's how you get to the part where the ALJ says that the 10% time off from task limit is to cover the bathroom breaks that Dr. Kandikar anticipated. No more than 2 to 3 per an 8-hour day, no more than 15 minutes each. That's 10%.
But then she goes on, and this is record page 24, in the first full paragraph. She goes on to say, but noting that greater limitations during the flares would be inconsistent.
Understood that to be a reference to your client's testimony. Your client disagreed with his doctor and said, no, during flares, I need more than what my doctor says. And so this, to me, looks like the ALJ saying, I'm going with the doctor over your client's own testimony.
But then she's still wrong in not explaining why, because the vocational expert testified that that limitation would preclude work. And that is page. Got it. Here it is. I'm sorry. On record page 52, when asked if they would regularly require 2 to 3 unscheduled restroom breaks or unscheduled restroom breaks lasting up to 15 minutes per break, and that would be on a daily basis, the vocational expert responded, I think the biggest part of that would be the unscheduled, and then unfortunately it's inaudible. Then the expert goes on to say, if they were leaving the workstation when they weren't supposed to, that's not going to be tolerated.
Isn't that just that's just a dispute about the facts, right? Where the doctor said he'll have 15 minutes of notice. The ALJ, excuse me, accommodated that by saying, no, none of this fast-paced assembly line work, does 15 minutes notice, is that unscheduled or not? These are all kind of nitty-gritty factual questions of making sure that we're all speaking in the same terms, right? The ALJ was on the ground and was able to do that. And you're asking us to interpret unscheduled to mean something different, it sounds like.
No, you're right. Well, no, what I'm asking the court to do is the fact that the ALJ rejects that need, either we're not sure because her decision isn't really clear. If she accepted that from Dr. Kandikar, then she didn't explain why she didn't accept the VE testimony that would preclude work, which she has a right to do, but she has to explain why she didn't accept that testimony from the expert. If she did not accept Dr. Kandikar's opinion, as far as the 2 to 3 unscheduled breaks lasting up to 15 minutes, she did that based on a mistake of fact.
It seemed like she followed Dr. Kandikar's questionnaire response kind of to the T.
But if you go on reading her decision, I don't think she did, Your Honor, because she says, excuse me, she said that first that Pepper had, and this is quote from record page 24, that Mr. Pepper had no symptoms on Balsazide, and then she cites to exhibit 24F. That is not correct. Dr. Kandekar completed his questionnaire on January 22nd, 2019. He examined Mr. Pepper that same day, and on record pages 1184, 1187, and 1194, he documents that Pepper was taking Balsazide at the time. Record pages 1187 and 1195 document that at that exam, Mr. Pepper was, and this is quote from those 2 pages, positive for abdominal distension, abdominal pain, anal bleeding, and diarrhea. So again, her statement that he had no symptoms while on Balsazide is incorrect. At Pepper's last visit with Dr. Kandekar, that's in the record, that was on July 31st, 2019. Record pages 1168, 1171, 1173, and 1177 show he was still taking Balsazide, and that the treatment notes on pages 1169 says symptoms over the last 6 months are GI symptoms similar, and then in parentheses, 3 to 4 loose stools, some blood, fissure symptoms, no fever, obstruction symptoms. Later, further down on that page,
Counsel,
bowels
excuse me,
watery
Counsel?
or
Counsel,
yes, sir.
let me ask you a question. Now, we can, there's sometimes in these cases, there's a problem with mistaking the losing the forest for the trees. And the thing I wanted would that it seemed to me that the Dr. Kandekar's overall conclusion read something like this, that, and to quote, aside from the need to take restroom breaks, getting a job will help him psychologically and for health insurance. And, you know, we're talking about an individual who is in his 20s or whatever. And it seemed to me that Dr. Kandekar was saying, isn't that a little bit early to be giving up on life? Try to go back, get a job, see what psychological benefits it brings. It could help taking your mind off yourself and having a job and getting your mind fixed on workplace opportunities and the rest. It can produce significant benefits. And that's what Dr. Kandekar was saying. And I repeat, you know, the doctor seemed to me to saying for this individual, this is a little early, but it's pretty young age to be giving up on life. And that's what I read the doctor to be saying overall. What's wrong with that?
Well, what's wrong with that, Your Honor, is in all due respect to Dr. Kandekar, he's not a vocational expert. And the vocational expert testified that given his limitations that he opined Mr. Pepper would have if he did try to work, the need to have 2 to 3 unscheduled bathroom breaks lasting up to 15 minutes would preclude work. So while Dr. Kandekar's intents may be all well-intentioned for his patient.
You can probably refresh my memory on this, but I thought the vocational expert, there was some back and forth about that for sure. But I thought that the ALJ sort of addressed that and said, look, I'm going with the doctor's testimony, and on the doctor's testimony, this is going to work. Like the off task, my 10% off task limit is going to be sufficient.
But the vocational expert's testimony doesn't support that conclusion, and the ALJ didn't explain why she didn't accept that. She does not have to take the expert's testimony, but she does have to explain based on what evidence she was rejecting that part of the expert's testimony, and she did not do so. And so when you take both Dr. Kandakar's opinion and the vocational expert's testimony based upon that opinion, Mr. Pepper is not able to sustain employment. Excuse me. The ALJ also was mistaken in the belief that Mr. Pepper was not taking Balsalicide between his January 2019 visit and his July 2019 visit. Dr. Kandakar's July 31st treatment notes show that that's not correct. On pages 1167 and 1168, it shows that a Francis P. Hofstadler, apparently one of Dr. Kandakar's staff, noted at 9:43 a.m. that he was taking Balsalicide. Dr. Kandakar started recording his notes at 9:45, so that recording of what medications he was taken before he was seeing the doctor. And Dr. Kandakar electronically signed the progress note at 10:07 a.m. That's record page 1173. Record page 1171 documents current medications, includes Balsalicide. 11 page 1173 shows Balsalicide as active. So, and Dr. Kandakar on 1177 says Mr. Pepper is on Balsalicide. On March 4th, 2019, Dr. Kandakar recorded that Mr. Pepper was on Balsalicide. That's record pages 8, 9.
All right, counsel, thank you so much. You have some time reserved for rebuttal. All right, Mr. Feldman.
Thank you. Good morning. May it please the court. I'm William Feldman, a special assistant United States attorney, and I'm arguing on behalf of the appellee, the acting commissioner of Social Security. We ask this court affirm the judgment below. Now, as Your Honor was just referring to, Brian Pepper was just 27 years old when he applied for disability benefits. He claimed he was disabled due to Crohn's disease, as well as anxiety and depression. But as Your Honor just mentioned, Pepper's own gastroenterologist, Dr. Kandakar, opined that Pepper had a good prognosis on medication, that he could handle even moderate stress at work, and that working would, as just noted, would help him psychologically. Beyond that, no doctor in the record opined that Pepper's physical or mental limitations rendered him unable to work. Not one. And the treatment—
What efforts, counsel, what efforts was he making to find work and to hold down a job?
So, okay, well, Mr. Pepper previously worked at a Walmart for about a year, worked up to about 32 hours a week at times. He was part-time, but would approach full-time work. And during that time, that was actually after he'd been diagnosed with Crohn's, and while he was working with the disorder. And he also worked at a few other electronics companies. And I would say beyond that, he also firmly said how he wanted to get back to work. He was talking about how he wanted to, on the psychological side, I wanted to start a work program, and he could find a desk job, something doing technology. He could work. These are his own words. Now, beyond that, so the ALJ looks at a 1,000-page record, hears the testimony, and determines, okay, Mr. Pepper has these impairments. He has Crohn's, he has anxiety and depression, and he has some limitations from them. Certainly, he does. He's not cured. He's not symptom-free. That's not the finding of the ALJ. But notwithstanding those limitations, he could still do some jobs, and those are the jobs that are identified in the decision. Again, the key piece of this is on page 19 through 24 of the record, which is the RFC, the residual functional capacity discussion, or RFC. That's kind of where we're having the issue in this case. And there's, as Judge Harris was mentioning, the ALJ recognizes that in addition to the usual breaks that would happen during the day, say in the morning, the lunchtime, and the afternoon periods, he would have an additional 10% of the day, about 45 extra minutes, to use the restroom as needed for his Crohn's symptoms. Beyond that, the ALJ is also aware of his social anxiety. And so, for instance, said he could only do jobs that involve no more than occasional interaction with the public and coworkers. So after considering the record, considering vocational expert testimony, the ALJ concluded that Pepper was not disabled because he could perform certain unskilled light work jobs. Now, I think Judge Wilkinson mentioned the idea about seeing the forest for the trees, and this is a great example of that. I mean, here you have his own gastroenterologist saying that Pepper had no major restrictions, had a good prognosis, that working would help him psychologically. The ALJ's opinion well aligns with that. It says, okay, you have symptoms, but you can still work. And that's where he comes down and finds that Mr. Pepper's not disabled.
So counsel, I think there was some discussion by the district court, if I'm remembering right, about this new regulation on treating physicians. Is that regulation even implicated in this case where the ALJ did adopt the views of the treating physician and there is no competing medical opinion?
Well, okay, well, two things on that. One is we're under a new rubric that's no longer applying the treating physician rule. That was.
I'm sorry, that's what I meant.
Right.
Is that new regulation implicated in this case?
The new non-treating physician
Yes, call it
regulation,
that,
right?
yes.
And that's basically any doctor, you look at persuasiveness of the opinion based on supportability and consistency, how internally supported it is, how consistent it is with the rest of the record.
Right. But is that requirement implicated in a case like this where there is just the one doctor, the ALJ is adopting that doctor's views and there's no competing medical testimony?
Certainly the ALJ is obliged to discuss the medical opinion evidence, and that's done here on page 24 of the record. There's an extensive several page discussion or several paragraph discussion of Dr. Kandakar's findings and his opinion, and he says it's persuasive. I know there's been some discussion in the reply brief about the validity of the regulations under the Constitution or under the Social Security Act. I could address that if the court would like. I would only say that the rulemaking authority is broad for the commissioner, and we sought to develop rules that would allow for efficient and fair consideration of all the evidence. And the two most important factors are consistency and supportability. And so, and again, the ALJ addresses that. And again, everything aligns well. Dr. Kandakar says that he has mild Crohn's, essentially. I think you could boil it down to that. Would not prevent him from working. ALJ agrees. And that's it. And beyond that, I would say, to the extent there's any concerns on the mental side, no doctor finds that Pepper cannot work due to his mental impairments. In fact, Dr. Kandakar says he can work and working would help him psychologically. So
Counsel, I'm going to ask my co-panelists if they have any further questions for you. Judge Harris, do you have some more questions you wish to ask? Judge Rushing?
No, thank you.
Thank you very much, sir. We appreciate it. All right, Mr. Piedmonte, you have some rebuttal time?
Yes, Your Honor. Thank you. Excuse me. First, just to respond to Mr. Feldman's statement that he made more than once that no doctor said that Mr. Pepper was disabled. Well, if they had, he would have been over there arguing that's an issue reserved for the commissioner. They can't give that opinion. What doctors do is they give their opinions on functional limitations, which Dr. Kandakar did. The ALJ said she found that opinion persuasive, but her findings are inconsistent because if one, it's not clear if she accepted the opinion that he would need 3 to 4 unscheduled bathroom breaks and accounted for that, or if she was rejecting that. It's not clear if she was or was not. But then she doesn't explain if she did accept it. She doesn't explain why she didn't accept the vocational expert's testimony that would preclude work. This court numerous times in Mascio, in Wood, in Monroe, in case after case has said ALJs have to explain why they make the findings that they make. They can't just make conclusory statements. They need to give explanations. And here she's rejecting an expert testimony in theory, either the VEs without explanation or Dr. Kandakar's based on mistaken beliefs or mistakes of fact.
I thought the ALJ did a pretty good job here, but the basic point at the bottom is that your good client has to try. You just can't have somebody on disability, because a lot of times trying and working has great medicinal effects. And I think that's what really was driving a lot of this hearing below, is you have to give it a shot. You have to attempt, you have to try to make yourself a productive member of society instead of just drawing benefits for gosh knows how many decades it would stretch out. But it just comes down, doesn't it? You got to try. At that age particular, you got to try.
And I don't disagree with that, Your Honor. And Mr. Pepper did try. But the issue we're looking at today on this record, he's not able to. Now, he certainly could if he improves and is able to. Your Honor, I'm about to run out of time. May I finish responding?
Yes, sir, you may.
Thank you. If he improves and if he's, because there's other medication Dr. Kandekar wanted to try, but insurance wouldn't approve it. And he couldn't get some procedures done because the free clinic wouldn't allow them or wouldn't provide them. If he is able to get those things or get some further treatment and his condition improves, then he can come off disability. But based on this record, with this evidence, based on that vocational expert's testimony and Dr. Kandekar's opinion that the ALJ did or did not accept that portion, he is not able to work on this record. And I would ask that you remand this case for a rehearing for clarification on those 2 points. Thank you.
We thank you, sir. We'll take a 5-minute break and then resume with our third case. We'll take a 5-minute recess.
This honorable court will take a brief recess. States Court of Appeals for the Fourth Circuit.
All right, we'll begin with our third case. Is it Miss Resme? How do I pronounce it here?
It's Remy, Your Honor.
Miss Remy, we'd be pleased to hear from you.
Thank you. Good morning, and may it please the court. My name is Julie Remy. I represent the appellate in this case, Windsor Kessler III. Mr. Kessler challenges the validity of the probation office's computer and internet monitoring program participation agreement, which imposes a multitude of directives that amount to new conditions of release that substantially restrict his use of computers and the internet beyond the conditions set by the court.
Does special condition 3 still apply?
I would argue that it was effectively nullified by the
Where
judge.
did that happen? It looks like it still applies. I didn't see the court removing it. And at the hearing, the court certainly talked like it applied. So where can I find in the record that it was removed?
It does still appear in the JOC.
Okay, so it still applies to him.
It is still there. However, I think we have to look at other things that have happened, such as, for example, because that condition says that he is not to use any computers except for purposes of employment.
Without probation's permission.
Without probation's permission, correct. However, we've also got the court telling Mr. Kessler that he's allowed to view pornography, which has nothing to do with employment. Which is also consistent with statements that the court made at the hearing, which when you compare them to the assertion that condition 3 still applies, becomes very confused for me and certainly for Mr.
He has
Kessler.
special condition 3, and then he says, I want to use a computer for school. And so probation says, we will approve that, right? Special condition 3 requires us to approve uses. We approve that use, but we want the court to impose 2 more conditions, which the court does. It says if you're going to use a computer and they've allowed you to use it for school, there's 2 more conditions. So now he has 3 plus all the other conditions, but he has these 3 about computer use, right? And probation still has to approve uses beyond employment. They have approved the use to use it for school. And then in response to your objections, the court noted that it didn't feel like it could legally prohibit him from looking at certain things on the internet.
Correct. That is correct. And the court also said to Mr. Kessler, trying to make clear to him what the parameters were, said to him, and the starting point should be an assumption that he has only authorized to the most limited use of the computer to conduct broad internet searches on topics that are not illegal, to engage in email communications with other persons on topics that are not illegal. He can go into that with this.
So how many conditions now are there that are as a result of these revised supervised release conditions? How many conditions are there to which Mr. Kessler is now subject?
I'm not sure I completely understand the court's question, but is the court talking about the directives?
Yeah.
Yeah, there's about 25 of them. And about a third of those are being challenged as overbroad. I'm sorry.
A third of okay, but the theoretically there were 25 conditions. Okay, has there been any Article 3 review of these revised conditions?
No, we would argue that there hasn't. And we were asking the court on March 1st to exercise some control over the probation office. And that's because we saw some clear problems with the directives contained in that agreement.
I find this case so confusing, sort of the posture we're in. It looked to me like at the 2021 hearing, right? It's a revocation judgment finding your client responsible for using marijuana and just restoring the prior supervised release terms and conditions. And then you said, or counsel said, well, there's going to be some challenges.
Yes.
And so I was like, assuming you'd be back in district court with some challenges, but that's not what happened. Instead, you came straight to us with the challenges. And I don't understand how that works.
Well, the
That
court
was just like an informal colloquy you had at the end of this revocation proceeding where you sort of anticipated some challenges that might someday be brought, and then you brought them here for the first time.
Well, it was kind of a unique way how this all developed. I mean, Mr. Kessler is not presented with this agreement until February 9th, 2022. This is right after we first appeared for the violation of supervised release hearing. He's approached, I'm there, this is in the record, it's talked about during the hearing on March 1st. And he's approached for the very first time with this list of directives. And the very first time that we had a chance to ever raise it with the district court was on March 1st. And it was introduced in the hearing as an exhibit during the hearing. And it was discussed. The court referred to it as the contract. And
So why didn't you go back to the district court with a motion to modify or clarify or whatever you wanted?
well, I think that's where I was heading. However, the courts basically invited the discussion right then and there. And my view of it was that this was essentially would fall under condition 13, which was just being reimposed by the court, which is that Mr. Kessler must follow the instructions of his probation agent. And how we've raised this is that the probation office is really gone outside of its limits here. And we're begging the court.
Raise this in front of the district court. It just seems like the factual premises running around this case are very unclear. Like what exactly is being challenged? Where is this coming from? And had you raised this in front of the district court, we'd have like a record that would explain, is this about that general listen to your PO condition, or is this actually under condition 3? Like all of this could have been clarified at the district court level.
Well, we very, very clearly challenged the agreement to the court right there at the end of the hearing on March 1st. The court was very aware of what we were talking about.
You think the challenge you're bringing now was squarely before the district court, the delegation challenge, the overbreadth challenge to something like 9 conditions? You think all of that, the district court had that?
Well, what we said to the court was that there were challenges to what we believe were new conditions being set by the court, or excuse me, by the probation office, which I think does imply a delegation issue. And that there were certainly vagueness problems and as I said, we thought that there would be some difficulty complying because of such vague terminology that's included in these directives. And we were essentially asking them to get involved.
Counsel, what would be your objection to sending this back and raising the objections with directions that the district court look at the vagueness and overbreadth challenges and the degree to which any kind of new conditions were actually tailored to the offense, or whether they went beyond the offense and take a look at the factors and the conditions under Section 3583. We've made clear that the conditions have to be tailored to the offense. The problem I have here is that I think the probation officer just went wild. And he presented this individual with all these conditions and said, here, sign this. And so, maybe got a signature, maybe not, but that's no substitute for hearing when somebody just, shows you, take it or leave it. There just has to be some Article 3 input into this. I mean, probation officers play a big part in the scheme, and they certainly have some interstitial leeway. But I mean, the probation officer looked a bit like he was an Article 3 judge. That at a certain point, these are questions of degree. At a certain point, it becomes problematic. There are so many conditions here that and they're so minute and everything that it would be hard for anybody to follow them. And what you're likely to have is a series of minor infractions, or maybe major infractions, but minor infractions. And I don't understand why this whole business couldn't be simplified. Do you see my concerns with what happened?
Yes, I agree with the court. And I think that the reason we're here now is because I tried to raise it with the district court, and the answer I got was essentially, Mr. Kessler's going to do what the probation office tells him to do. And that is why we brought it to this court.
I thought the district court said something like, I think these are good conditions. These are, because this is a standard contract if you're going to use a computer on probation. And the district court was familiar with it. And I think it said something like, I think these are a good idea. And then went through them when you made particular objections and took out, like we talked about, the adult pornography, but then pointed out almost all of these either are exactly the sort of thing that got him in this position to begin with, like having child porn on DVDs, peer-to-peer sharing, et cetera, or they're tailored to prevent circumventing the monitoring. And the district court made a particular finding that he was a sophisticated computer user, knowledgeable with circumventing, right? So what's the problem here? And didn't the district court address it?
I didn't hear any real answer to the questions or didn't see any real exercise of control by the district court in its response when it was challenged on March 1st at the end of that hearing to address, as was just discussed, a probation officer that really is out of control. These directives appear to be mounting.
The probation officer didn't invent this. This is something that applies. This is a contract that applies to any probationer who uses the computer. The district court was familiar with it. The district court said, I think these are good conditions. They apply to making sure that the monitoring works, that it doesn't get circumvented, that you're not able to hide something from the monitoring, right? You have the one point about interactive sites, but it seems for this particular defendant, that's perfectly legitimate because he was previously convicted of contact sexual abuse offenses.
No, he was not. His underlying offense.
His state offense, wasn't that it?
Yeah, yes, his state offense did not include the internet, is my understanding.
Right.
There was a contact, but the underlying offense for this case did not involve contact with a minor. And that really does get to the core of where this argument
That's why he
ultimately
was
will
a
lie.
registered sex offender, right? Because he had multiple contact.
I'm sorry, Your Honor.
That's why he was a registered sex offender.
I didn't represent him in the case that was.
I can point you to the JA if you need to know where it is. It's at 25 and 33 on the sealed joint appendix.
Well, I don't have any dispute that he was a registered sex offender and that the prior offense involved contact. I'm not disputing that. I don't believe it involved the internet. But the underlying offense for which he is under supervision was non-contact. And yes, it involved the internet. So I think that this would be the non-contact variety when we start talking about the propriety of a broad internet ban, which is exactly what the probation office is trying to do.
Is this a standard form that with respect to registered sex offenders that this is this one-off, or is this a standard form that's presented?
I don't know. I think that it appears to be a standard form where some boxes will be checked for certain offenders. I didn't know until March 1st during the hearing which of these would apply. I asked the court that. I said, to the court, I said, I don't know if all of these boxes are going to be checked, and the probation office chimed in and said, yes, every single one of these is going to be checked for Mr. Kessler to follow. And
there's a chance, because it seems to me that a lot of these conditions are obviously correct in light of the background here. And not only, as Judge Rushing points out, is he a registered sex offense, but a lot of the conditions stem directly from the original sentence. And he pled guilty to downloading child pornography, and he put an incognito device on his computer to discourage any kind of monitoring. And so there are a lot of these conditions that appear perfectly tailored to the offense. But, I mean, you get this double-edged sword where the internet is indispensable to your client, but at the same time, it's a vehicle for carrying out these heinous criminal acts. So I'm not sure you would fare all that well before the district court. You might, some of the conditions seem to me a bit vague and subject to overbreadth challenges. But there's a lot in these conditions that are going to be perfectly valid even if we remand. So what's your response to that? This is not any kind of free pass.
Correct. And if I may, I am over time. If I can just have a few moments to respond to the question. There is certainly a narrow tailoring requirement. And, you know, I think the question that I have is the usages that are targeted by the probation office through these directives. I mean, what evidence is there that the monitoring and inspection requirements don't resolve all of these concerns? So in other words, how does allowing Mr. Kessler to have usage of the internet and computers so that he can function in daily life, how does that hinder the probation office's ability to monitor his internet use and to exercise its authority to inspect any computers that he has? That would be the least restrictive means of controlling his behavior. And that's what the court did when it modified his conditions in July of 2019.
What's the worst? Give me an example of the conditions that you feel are the most susceptible to vagueness and overbreadth attacks.
Well, as far as starting with the vagueness, we look at, just a moment. There's actually more that are subject that are challenged to overbreadth than vagueness. For vagueness, we challenge conditions, excuse me, 6, 7, and 9. So for example, 6 may only access the internet or other online services by an account pre-approved and authorized by the probation office. 7 may only access email accounts, instant messaging services, chat rooms, or other online environments which allow for user interaction via accounts pre-approved and authorized by the probation officer. 9 shall not access any chat room or other online environment. These are extremely vague terms. And
they're broad terms.
They're very broad terms.
Breadth is not vagueness, right? And the district court clarified that. The district court said, yeah, by this, I mean, he's not on the internet for entertainment. Any place that he wants to go, any sort of interaction, the district court said, is going to need probation approval. The court said, that's what these mean. Court clarified it. And by doing so, the court said, it's really broad, right? The court made it quite broad. But breadth is not the same thing as vagueness, right?
I recognize that, Your Honor, and I agree with that. But I think when you're using terms like other online services, user interaction, I mean, any internet activity.
Right. He's prohibited from using the internet except for work or school or apparently adult porn unless his probation officer approves it.
Well, certainly, I mean, the court will determine how it views that. Our argument here is that the modification effectively nullified condition 3. And I think that it was vulnerable. It would have been vulnerable to attack.
Don't you need a court order to nullify condition 3?
There was a court order.
But did the court ever take condition 3 out?
It didn't actually remove it. But I would say that had that July 2019 modification not been enacted, condition 3 would have been vulnerable to attack following Packingham.
But that's not what happened, right?
It's not what happened. But I can tell you that the way that Mr. Kessler has been managed up to this point, and in comparison with the comments by the court, that he's permitted to engage in broad internet searches that are not illegal, that he's allowed to have email communication about things that are not illegal, that along with telling him that he's permitted to view pornography and the way that he's been supervised up to this point, all indicate and send him the message that condition 6 and 7, the modification in July of 2009 did rescind 3. So I understand what the court is saying, but functionally, and the way this has been played out has been very unfair to Mr. Kessler if that's the interpretation.
I mean, if there's a confusion about what it just seems to me that if there's confusion about what the district court meant when he said these things and what is the effect of that on condition 3, it would have been really good to ask the district court to have the district court maybe look at this before we get up here.
I agree with what the court is saying, that yes, it could have been handled more cleanly. And the answer that I got from the court in response to the challenge that we made, which was clearly challenging the entire agreement and pointing out specific examples of what we thought were vagueness and overbreadth and delegation. It's all implicit in there. And the court basically said, yeah, I don't have a problem with them checking that box because this is the overall instruction to him. And then says in the same breath, he can engage in broad internet searches that are not illegal. He can have email communication with individuals that are not illegal. That does not appear to be, excuse me, I didn't mean to cut off.
So you have three basic objections. One, I guess, is a vagueness objection. Two is the overbreadth objection. And three would be a numerosity objection to just the sheer number. Am I correct that those are your three points of attack?
Yes, I think that is fair. I mean, there's about 25 of these things, and at least half of them are challenged, and they're taken as a whole. These are extremely onerous conditions, and Mr. Kessler is on probation for the rest of his life or on supervision. So that means that there needs to be the greatest justification for these conditions, and I don't think that has actually been established in this case.
Would your position be a bit stronger if you didn't have this history of this incognito device to discourage and prevent monitoring and the history here, not only with the original offense, but also you've violated conditions that were previously put on you. So are we giving you a second bite at the apple?
No, Your Honor. Let me clarify, please, the circumstances surrounding this incognito mode. First, the court found him not in violation of that. Incognito mode is essentially it's not something that you seek out and install. I think it's available on virtually any Apple iPhone. It's just a toggle on and off. But we went to great lengths to demonstrate that there was instruction to Mr. Kessler to use that application because there were problems with people dropping into Zoom classrooms at Towson University where he attended. And so there were certain security applications that were put on their side. And that was a workaround that he was given. But he was found not to be in violation of that because his agent never advised him that he couldn't. In fact, what I asked the agent during the hearing was essentially boiling down what the extent of the advice Mr. Kessler was given, and it was just conditions 6 and 7. That was the answer to the question.
All right, you've got rebuttal time, but let me ask Judge Harris and Judge Rushing if they have further questions of you.
No, thank you.
No.
Thank you.
Okay. Well, let's hear from Mr. Cunningham.
Good morning, Your Honors, and may it please the court, Michael Cunningham for the United States. If I may begin with the procedure, as Judge Harris's question sort of alluded to why are we here, I think that the procedural posture of the case in the district court suggests that we shouldn't be here, that in fact, the appropriate forum in which to address these objections to the extent that any were preserved would be in the district court. On March 1st of 2022, Judge Berdar held a hearing to address the specific questions of whether there were violations to 2 petitions that had been submitted by the probation office. This was after we had held a proceeding on the 9th of February in which the parties had intimated to an agreed upon disposition that Judge Berdar rejected and informed the parties he wanted to have us return to the court and litigate the actual issues at stake. And after careful consideration of the testimony, he concluded that, as counsel has indicated, the government had failed to meet the burden of preponderance of the evidence with respect to the allegation regarding the misuse of the incognito mode, to the extent that that was in violation of the modified condition, or I should say the condition of supervision as it had been modified.
Has
2000.
counsel, has Judge Berdar taken a look at the present set of conditions? Has he, however many 25 conditions and the vagueness and overbreadth challenges that could be raised with regard to them?
Judge Wilkinson, I apologize, sir. I didn't catch the first part of the question. I understood it had something to do with the 25 conditions in the contract.
Has Judge Berdar had the chance to look at the present set of conditions, all of the present conditions?
Judge, the record, as has been indicated, is somewhat thin on that, but I would suggest that Judge Berdar did look at the contract. It was offered up by the appellant as an exhibit at the hearing below. And contrary to the assertion that there were any specific challenges to the 25 actual conditions that are articulated in this form, and I would submit, Judge, that by its very nature, it appears to be, at least within the District of Maryland, a standard form. And by looking at some other cases that this court has heard, specifically Cook, a form with very similar language and a similar name was used. So I would suggest that the form is...
I'm asking you whether Judge Berdar has had a chance to look at the present set of conditions.
I believe that he did, and it's reflected in the record when he specifically invited counsel to address any of these forthcoming challenges. And I think that in and of itself bears on the question of whether indeed there were objections that preserve for an appellate review other than plain error. Because
what is your objection to remanding this case and getting the whole thing straightened out? It's not, the problem I have is that it's not in a clean kind of posture. And I'm just not sure from this record exactly what conditions he approved of, what conditions he disapproved of, if any. I think I don't know how he resolved these vagueness and overbreadth challenges. I don't know that you have anything to be particularly afraid of on a remand, because the conditions, a lot of them are tailored to the offense. A lot of them seem to be perfectly reasonable, but some of them do seem to be vague and overbroad. And what we're talking about is the rest of the individual's life under a set of conditions. It would be almost impossible to use the internet in a way without violating one or more of them. And what's wrong with just getting some Article 3 input into this? Because the exact procedural history before in the district court is a little bit fuzzy.
Judge, first of all, to respond to your last point there, I don't think that there's any problem with getting additional District 3 input to clarify things. I would certainly be remiss if I suggested that the district court would do some injustice by further considering this. But I think that the government's position in this is that Judge Berdar was very careful in his approach to this case. I mean, beginning with the fact that he actually listened and did not find Mr. Kessler in violation of condition number 1, respecting misuse of the incognito.
Okay, Judge Berdar is a very careful judge, and he does, at the present set of conditions and the vagueness and overbreadth challenges and the impact that the numerosity of the conditions has is likely to have for the future. Isn't it good to get a comprehensive opinion on these different conditions and a ruling on some of these challenges? Some of these provisions. I don't think there's a strict vagueness and overbreadth analysis that should be applied to supervise release conditions. That strikes me as going too far, but it's just not clear to me exactly what he did consider and exactly what he did not consider. And it seems to me that the probation officer acted somewhat aggressive, or right outside the courtroom and say, here, take it or leave it. Why not just clean the case up?
Well, Judge, with respect to the comment about the probation officer aggressive, and I think earlier during counsel's argument, you used the term wild, I would respectfully suggest, Your Honor, that the probation officer in this case was not wild, and contrary to Mr. Kessler's own stated opinion that she was out to send him back to jail, she actually did not recommend, in the context of the violation, even if it had been a violation that encompassed the misuse of the incognito mode, she wasn't recommending in terms of incarceration. All she was actually seeking in this case were essentially two things. One, an admonishment from the court, which shouldn't have been necessary. And two, an order to participate in sex offense related mental health counseling, which hadn't been part of the district court, the underlying district court's initial conditions of supervised release. Judge Bredar rejected that second request specifically because he had not found him in violation of a condition relating to the underlying crime involving access to child pornography, in this case, possession of child pornography. So I think it very clearly reflects Judge Bredar's care and carefulness and attentiveness to this court's admonishment as to how he's to conduct himself with respect to sentencing. He carefully went through the 3553A factors as they relate to this. He acknowledged that misuse of marijuana is, relatively speaking, a very minor offense. And he considered the extenuation and mitigation as presented by the defendant. I would note that there was no comment, well, if I may strike that and say, go back. The probation officer had indicated that all of the particular provisions would apply. This particular form had been presented to the defendant and counsel 3 weeks prior to the March 1st proceeding. There was plenty of time to specify which of these conditions are offensive to you. Which of them do you think are overbroad and or vague or constitute an inappropriate delegation? I would note that most of the conditions impose a restriction on computer use and internet access unless there's some consultation with the probation office. And that's what this very court has counseled, that where there's an opportunity for the dialogue between an individual being supervised and the supervising probation officer, that actually obviates concerns about inappropriate delegation, vagueness. If in fact the defendant has a question or a concern that I want to do something that my probation officer is prohibiting me from doing, there is always the opportunity.
Right, well, what I'm thinking is maybe some of the concerns here can be alleviated by a simpler set of instructions. Maybe you can reduce the 25 to 4 or 5, with the emphasis being on seeking the approval of the probation officer and consultation with the probation officer. And because, as I say, you know, the vagueness and overbreadth analysis that we apply in normal First Amendment challenges seem to be a little bit relaxed, should be a little bit relaxed, and you give the district court and probation officer broader latitude. But might it not be advantageous in these cases to take the 25 conditions or however many and reduce them at least to 5 or 6 that incorporate some of the very general points that you have made. You've actually given a pretty good summary of what a reduced set of conditions might entail. But, you know, the problem with having this many, 25, it's hard to say that there wouldn't be inadvertent violations. Now, they wouldn't be major violations and they wouldn't require major sanctions, but you know, you'd be there are just a whole lot of tripwires here. Is it possible? Let me just ask you, is it possible to reduce the number of these and bundle them into 5 or 6 prohibitions with the emphasis upon the need to secure the probation officer's approval? Can this be presented in a more intelligible form?
And in answering that question, keep in mind, would it make them more or less vague to combine 25 conditions into 4 or 5?
Thank you, Judge Rushing. I think that actually hits on a point that I would have responded to Judge Wilkinson's questions. First of all, Judge Wilkinson, I don't presume to have the expertise in the context of supervising individuals sufficient to say that, yes, they could absolutely reduce this. I actually think that the tension here, and if I can borrow something you said, is that the tension between creating a prolix code of Hammurabian proportions versus providing the sufficient kind of guidance so that supervisees are on notice as to what is prohibited. Again, I note that most of these conditions require consultation with the probation officer. And if there is a dispute, then there's an opportunity to present that to the district court.
And is it correct that, I mean, there's been a lot of talk about 20 something. I thought only 9 had been objected to in front of us in the opening brief.
Well, Judge,
is that right?
That's correct. Actually, the brief specifies them. I would suggest that if you look to the district court, there wasn't even that. There was an objection to the one with respect to pornography, which ironically, the defendant is as support for Judge Bradar's conclusion that here was a smart individual who was pretty savvy about computers. He knew about the Packingham decision from the Supreme Court before he even actually came on to supervision. And indeed, there is a dispute of fact as to whether or not he had seen this particular contract or the agreement prior to. The probation officer testified that both she and a colleague had gone through, well, yeah, I misspoke there. A colleague had spoken to Mr. Kessler before, while he was still in a halfway house, about how he would be supervised in certain things, during which time frame it came up that he would want to use the computer. And even when he was in the halfway house, the probation office, essentially, he signed a waiver of his right to a hearing and agreed to the modifications in 2019 that were actually they were presented to District Judge Garbus, but because he wasn't handling the case anymore, Judge Bradar actually signed the modification in 2019 that included the relaxation on his proscription for having and using computers and the internet.
What about the present set of conditions? Did Judge Bradar sign anything with respect to all of the present set of conditions?
No, he did not, Your Honor. And in fact, part of the
wouldn't that be nice? Wouldn't it be nice to have him look at the present set of conditions and sign off on those?
Judge, he imposed the same conditions of supervised release that were extant prior to the violation. And he was constrained in that respect because the violation that he found was only as to the use of marijuana. The government invited him to impose a condition involving involving the mental health counseling, and he specifically declined to do so because he felt that not having found a violation of the restriction on computer use and internet access, he wasn't therefore going to do anything with respect to those conditions of supervised release that were already in place. So I think that also constrains the scope of review in this case, because it didn't raise anything at the district court with respect to the conditions involving computer use and internet access.
Well, I guess your colleague, I know what you were saying, and I have given this way more thought than I wish I had. I hear what you were saying. He says, I'm just reimposing the same conditions that have always been in place, by which I think he must mean condition 3, just no internet without PO approval. Your colleague, though, says, no, these were this list of 25 was imposed for the first time at that proceeding, right? That I believe is sort of the premise for why we are here, that no, these were imposed. This list of 25 pops up for the first time at this hearing in front of Judge Bradar. So what is happening here?
Judge Harris, I would respectfully suggest that these actual conditions were expected by probation, at least, to have been in place as of the modification in 2019. Now, unfortunately, COVID seems to have had an impact on this case, like probably so many other things that this court has dealt with. And indeed, to the extent that the probation officer acknowledged that typically before an individual is given computer access through the remote monitoring program, they would have the person sign this document in advance. Unfortunately, that didn't happen. Actually, the probation officer said it was because Mr. Kessler, the supervisee, was resistant to that. He didn't want it to impede his authority to access adult pornography. Again, reflecting his knowledge of the Supreme Court decision and how it impacted. So unfortunately, the probation office should have at that time probably gone to the court and said, here are the circumstances. We need clarification of this proposed modification. The modification was appropriate in light of Pakenham and the objectives of supervised release, not to thwart people in their ability to get back on their feet and move into being a productive member of society. But Kessler was resistant to what probation was trying to do to help him. And at least according to the probation office, would say not only to her, but other people that he thought it was her design to send him
All right,
back.
so the answer that you're giving to my question is that no, Judge Bradar did not sign off on the present set of conditions.
He incorporated them by reference, Judge. He acknowledged when the probation officer said that they would all be signed, that was part of where he saw things, what he perceived to be the landscape moving forward. So I would submit that he acknowledged that.
So the answer is no. So the answer is to whether he signed off, I mean, incorporating by reference in this, the question is whether the answer to the question of whether he considered these particular set of conditions and whether there was Article 3 input into this particular set of conditions, your answer is no.
Your Honor, I see I'm over my time. May I take a moment to respond?
Yes, absolutely.
Your Honor, I think to the contrary, he did understand these conditions. He recognized the scope and breadth of them. He believed that they were appropriate, and he did consider them and include them in his decision.
What evidence do we have from the record of that?
Judge, at the conclusion of the hearing on March 31st, he addressed when counsel said that she expected there would be future challenges. He asked for specifics. He responded as to the one regarding adult pornography that in fact, there would be no proscription on adult pornography. As to the general complaint of vagueness, he acknowledged that he had reviewed them and found them to be appropriate given Mr. Kessler's history with supervision. Your Honor, unless you have any other questions, I submit.
Let's hear further from Ms. Ramey.
Yes, Your Honor. Is there a specific question that the court has that it would like me to address? No. I do want to go back to this notion about the record and Ms. Miller, the probation agent, and when this was presented to Mr. Kessler, because I think the record is very clear that it was presented to him for the first time on February the 9th. And she was asked by the court whether or not she had gone over that contract with him. And she essentially responded, and this is on JA 169 to 70. She essentially said that, well, she had visited him a couple of times at Towson University outside on the campus, and she says we discussed it. But then the very next sentence is, I never went over the exact conditions at that time. And the court says, okay, so you didn't go through and say, listen, you got to do this, you got to do this, you got to do this. And she says no. And Mr. Kessler testified the very first time he saw it was on February 9th when we were standing outside the courtroom. And certainly, she seemed to agree with that during the hearing. So it was first presented to him on February 9th of 2022. And the other point that I wanted to respond to is that, when I made the objection, or not the objection, but when I brought the challenges and the way I said it to the court, I think it was very clear to the court that I was challenging more than just the specific examples that were discussed. I said, there are a number of challenges here. There are a number of problems here that I see. And the response that I received from the court, I took to be a response to really all of those objections, because they are such similar language in each of these separate conditions that we're claiming are vague. I mean, a lot of them kind of say the same thing, or they could be read to say the same thing. They're just using slightly different terminology. So they're very, very similar. And that was taken to be really the answer for many of those very similar conditions.
All right, can I just repeat my question? And what input did Judge Berdar have? What Article 3 input was there by Judge Berdar into the present set of conditions? I've given an idea, well, the previous hearing incorporated them, and they were incorporated by reference, and the previous hearing took care of it all, and this really isn't much of a modification. What Article 3 input was there into the present?
I missed sort of the end of the court's question, but as far as the court did not have anything to do, or these conditions, this monitoring agreement was not presented to the court until March 1st. It was never brought up or raised at the February 9th, 8th hearing, because it wasn't presented to Mr. Kessler until after we walked out from that hearing. It was after that hearing was concluded. And so the court's weighing in consideration of these directives is limited to what we see in the record from the March 1st hearing, which was, a paragraph essentially of a response, that really, I think, failed to address the core concerns that we're presenting here, which is, the overbreadth, the vagueness, the clashing with Packingham and Ellis and Hamilton as decided in this court. And so I think the court does need to go back and look at these things. And I think it's right to remand it.
I'm sorry, can I just ask, so about, in terms of Article 3 input, and maybe this is about your delegation challenge, which we haven't talked about much today, but that is one of your challenges. And I mean, the general rule, right, is that you don't need Article 3 input. The Article 3 input came in. I know you don't think Condition 3 is still operative, but it's right there in the judgment. So let's assume for a minute it's operative. There's your Article 3. I'm delegating to the probation office what sorts of conditions ought to be imposed here. And obviously, if they are challenged in court, then you want an Article 3 resolution of that challenge. But it's not as though a judge automatically has to sign off on all of this, right? In addition to the original delegation, which we've said is fine under, I think, Comer, that's the Article 3 review, right?
Just the signing off on it because because condition 3 exists?
Well, I mean, a judge entered that condition that you have to get PO's approval in order to use the internet. So there was an original Article 3 delegation. So maybe this is just what you were trying to say is that delegation was too broad to justify these 25 conditions. Why do we need additional Article 3 review now if that was a legitimate delegation?
Because I think the court does need to consider the core issue here, which is that the probation office is essentially trying to ban, it appears, Mr. Kessler from accessing and using the internet. That clashes head on with Packingham and Hamilton and Ellis. The court has never considered that. And I think it has to in this case. And so, whether this is, I've raised this as a condition 13,
Do you agree with, Judge Harris is pointing out that neither our court nor any other court that we're aware of, we've said, has ever reversed a condition where a court says no internet without probation office's approval. No court has said that condition is an impermissible delegation. We've approved of that condition numerous times. Do you disagree with that proposition?
As an impermissible delegation, the court would be setting the condition, the restrictive condition. And so
that's what happened here. There's a condition that said no internet without the probation office's approval. And that's the delegation. And then the probation approves certain things, adds certain conditions. And as Judge Harris is pointing out, if you have a problem with certain conditions, you can raise them. But the Article 3 review has happened, right?
It happened in 2012 when that before Packingham was decided, before this list of 25 directives ever exists and is ever presented to Mr. Kessler.
And we've said that's not an improper delegation.
You said that my focus here is on the directives, right? Now,
so that's not an improper delegation.
The directives?
Giving the probation officer the authority to approve or disapprove internet access is not an improper delegation.
No, I agree that this court has said that the probation office can make those kinds of determinations. However, in every case where that's happened, there has been a situation. This is where we just disagree, and the court's going to decide how it's going to decide it. Whether or not the modification in July of 2019 is effectively rescinded 3, because if it did, that changes everything. If it didn't, which it sounds like the court is interpreting it that way, well, then yeah, I think this would be consistent. I'll concede it that would be consistent with the prior cases where and it was Comer. Where the court has said that, yeah, probation officers can get involved in making those access determinations. And in each one of those cases, Comer, Bush, Halverson, it was all a situation where the court had set a restrictive condition and the probation agent was simply allowed to determine when exceptions might apply. Now that I will concede that where we stand right now, that would be permitted if condition 3 was not rescinded. And I see that it appears in the paperwork. I appear that it's in the documents. But the way that and I think this does come back around to some fairness that I think has to be considered here, because the way that Mr. Kessler has been managed up to this point has certainly not been in line with no internet access, but for your agent's approval. It's been much looser than that. And it's really functioned in a way that lends itself to an interpretation that 6 and 7 undid, that essentially nullified 3. And then you've got adding to that.
Is the point that you're making, there can be a proper delegation, but at the same time, the situation would call for at least the exercise of the delegation.
I'm sorry, I missed the very end of that. The exercise of
open to challenge. In other words, is that what would be a proper delegation? Or let's say there's no improper delegation, but that doesn't necessarily preclude the fact that the exercise of the delegation should be open to challenge when a court thinks that there may be some basis for the challenge.
Yes.
Do you see what I'm saying?
Yes,
that
sir.
you don't need to raise an improper delegation necessarily to hold that if there is a basis or some basis for a challenge in the exercise of the delegation, that it should be heard.
Yes.
All right, is there anything further?
I have nothing further. Does the court have any other questions for me? Thank you. Thank you for your time.
All right, thank you. All right, we'll move into our last case.
May I begin? Your Honor.
Mr. Dahl, please proceed.
Thank you, Your Honor. May it please the court. My name is Christopher Dahl for the law firm of Baker, Donaldson, Behrman, Caldwell, and Berkowitz. Despite the volume of this record, and I'm sorry, I'm representing DGS Construction LLC, which I'll refer to by their trade name Schuster during this argument. Despite the volume of this record and the complexity of the cross issues, there are really only a few core issues that matter on this appeal, and only a few items of evidence that are truly material. My client's case, both in winning summary judgment and now challenging the denial of Rule 50 and unjust enrichment, is quite simple, quite straightforward. Schuster did not agree, and appellees did not expect the payment of fringe benefits on overtime hours, and it is not unjust for Schuster to have paid appellees at the rates set forth in the contract documents as understood by the parties. Appellees, in contrast, invite this court to follow it down a winding path, relying on an unpublished sub-regulatory opinion of an administrator at the Department of Labor without rulemaking authority, interpreting an inapplicable statute to retroactively bind Schuster to make payments it never agreed to make, in which the appellees never expected to receive, based on a law that was expressly disclaimed in the contract documents. I'll begin briefly at the dispositive motion stage, where the district court properly granted Schuster's motion for summary judgment on the statutory wage payment claim. Distilling the facts to their most simple, Schuster was a subcontractor on a private construction project, and under those contract documents agreed to pay wage rates that were derived from the wage rates adopted by the DLLR for prevailing wage projects. Those rates are set forth in the S3, which for the summary judgment record is at JA 188. Importantly, while the document states that those rates were derived from the DLLR wage rates, that document expressly provides that this project is not subject to state law regarding the payment of prevailing wages or the Davis-Bacon Act. And on that record, the district court properly found that appellees could not prove a promise by Schuster to pay sufficient to give a rise to a claim under the Maryland Wage Payment and Collection Law. The court recognized that workers were told it was a scale project, and that scale was a clear reference to this section S3 of the project manual, but that the project manual did not state that fringe benefits would be paid on each hour work to include overtime. And because no other state law provided that a promise to pay fringe benefits constituted a promise to pay them on overtime hours, and noting, even though it wasn't binding, that the DLLR had itself not consistently required fringe benefit payments to be paid on those hours, the court properly granted Schuster's motion on that count, and we'd ask the court to affirm as to that aspect of the cross appeal. Despite finding as a matter of law that the contract documents didn't obligate Schuster to make these payments, however, the district court did allow plaintiff's unjust enrichment claim to move forward. Again, we're not challenging that on summary judgment. Yes, Your Honor.
Oh, I'm sorry. I was just gonna say, finish your thought.
Sure. But we highlight the error in that ruling simply because it creates context for the errors that followed. In our view, the district court should have dismissed the entire case at that point. It didn't.
I guess I am confused because you said despite the fact that the district court found the plaintiffs couldn't prevail on what's basically a contract claim. I was promised these benefits under the wage statute. It did allow them to go forward on unjust enrichment, and that doesn't seem at all intention to me. I mean, isn't that the point of unjust enrichment? There isn't a contract, but there may still be an equitable claim for why the defendant should have to disgorge the money.
Well, we would dispute that any party had said there wasn't a contract. Every party said there was a contract. The dispute was about what the terms of the contract were. Now, under Maryland law.
So these plaintiffs had no enforceable promise as to these fringe benefits against Schuster.
Right.
But I don't think it is inconsistent with that or intention with that to say, nevertheless, they can proceed, or in fact, precisely because of that, they can proceed under unjust enrichment to see if they can make a case that it would be inequitable for the defendant to keep this money rather than disgorging it.
Well, again, noting that our summary judgment ruling that is not on appeal. I will respond anyway that we would disagree because unjust enrichment isn't available where there is a contract, and at-will employment is a contract. Again, water under the bridge at this point.
Okay.
And secondly, that, as argued throughout and now frankly clarified by a more recent opinion of the Court of Maryland, the then Maryland Court of Appeals in the identically titled DGS Construction LLC via Maya, the expectations of the parties very much are at issue when determining whether there's a claim for unjust enrichment in the context of an at-will employment case. So the Amaya case came down during the pendency of this appeal and stated that whether workers who happen to be workers on this same project, although in the Amaya appeal, it was involving a different subcontractor, that whether they had an unjust enrichment claim turned on entitlement to compensation. And we would say that entitlement to compensation very much is tied up, as we've argued all along, with the concept of the expectation of the parties. And I think that is irreconcilable with allowing unjust enrichment to go forward, either at summary judgment or for the purposes of this motion, of this appeal we're here today, on which we're here today, the denial of the motion on Rule 50B, to which I will now turn. The elements of enrichment are not. Yes, Your Honor.
Before you move on to that, I understand your position, and I'm sympathetic to it that a breach of a contract is not a tort, just as a basic matter, and it is an odd thing to have a recovery where there has been no breach of contract. But I want to know, where has Maryland law precluded a tort claim or an unjust enrichment claim or an equitable claim where the breach of in instances where a contract claim is not available and a statutory violation is not available? I think it's generally agreed that there's been no breach of contract here and there's been no statutory violation. And a great many states would say that's the end of it. But where exactly does Maryland claim such as unjust enrichment from going forward if the elements of the claim are met?
The unjust enrichment is undoubtedly available where there is no contract or where there is no statutory claim. Here, there was no breach of contract claim, but that is a different proposition than there is no contract. At-will employment is a contract. It is a contract terminable at will by either party throughout the duration of the case. And again, I'm now arguing, and I don't want to take the court's time arguing a point that is not presently on appeal and proceed to my argument on unjust enrichment. The elements are not in dispute. Unjust enrichment has three elements dealt forth in probably the most important case in this case, Hill v. Cross Country Settlements, LLC. It's a benefit conferred upon the defendant by the plaintiff, an appreciation or knowledge of the defendant of the benefit, and the acceptance or retention the defendant under such circumstances to make it inequitable for the defendant to retain the benefit without the payment of its value. Beginning briefly with benefit, this was an element that, we've highlighted in our papers that plaintiffs struggled to articulate below, and really with good reason, because the facts of this case do not look like a standard unjust enrichment case. As set forth in our papers, we feel that benefit is tied up in this new notion or newly clarified notion of entitlement to compensation announced and clarified by the Court of Appeals in the Amaya case, which requires appellees really to prove three assumptions.
Should we read Amaya to have changed the elements or done any real work on that? That you're absolutely right that it says they have this sentence about unjust enrichment also turning on the entitlement. But Amaya was deciding another issue, and then it said basically this issue will affect the unjust enrichment ruling also, because that also turns on an entitlement to the benefit. And so we're going to send both of those claims back. And as a federal court, I'm always a little cautious about how much should I read into what the state court is saying about its elements of its torts.
Your Honor, we do not feel that the Amaya case changed the elements of unjust enrichment. Amaya is, however, the first articulation by a Maryland appellate court that we know of at any time from the founding forward of how unjust enrichment applies in the context of at-will employment. But it doesn't change. It's not a sea change in the law. It's not. It's
So
just
the-
a clarification.
So entitlement to the benefit still means what Maryland's other unjust enrichment cases say it means. That you're not trying to say, this means you have to have a promise. This means you have to have some sort of enforceable agreement to have unjust enrichment.
Well, we're saying that it is wrapped up in the expectations of the parties, and particularly, maybe I need to move on to the second element of unjust enrichment, because I think that's where it ties most clearly.
I'm just trying to, and you can move on. I know you have lots to talk about, but to me, I thought the difference between the state law, between the statutory claim and the tort claim is the statutory claim, you have to have a promise. You have to have, that's why you looked to the written documents. But unjust enrichment allows for consideration of a more generalized understanding of the expectation of the parties, right? Whether one party had been misled, it lacks the concreteness of a promise or promissory estoppel. Those sorts of unjust enrichment kind of takes all comers.
Yes, but the expectations of the parties, as your honors noted, do matter. And on that, I do want to, as my time is starting to run short, make sure that I address, most importantly, the second element of unjust enrichment, which is the appreciation or knowledge or appreciation of the receiving party of the benefit. So if we're defining the benefit as Judge Schwong ultimately did under Rule 50, yes, your honor.
Was that second element on the unjust enrichment, or whether they were aware that they were receiving the benefits? I mean, so many of these elements that you're talking about, I wonder whether they aren't jury questions. You seem to be wanting us to rule on them as a matter of law, but I'm just wondering, wouldn't somebody's awareness, or wouldn't the expectations of the parties or the relationship of the parties and all the things that feed into unjust enrichment, aren't they factually laden to a certain extent, or jury questions about what the relationship and interchange and expectations of the parties were? Why? I'm just wondering why. I mean, I'm sympathetic to what you're saying, but I'm wondering why. I'm not sure why the equitable claim is disallowed. And if the equitable claim is not disallowed, I'm not sure why it wouldn't be a jury question. It seems to me to be factually laden.
Well, because, Your Honor, we recognize under Rule 50, they need a fact. They need one fact to show that Schuster had knowledge or appreciation of this benefit at the time that it was conveyed or at a time that Schuster could have returned the benefit. And this is where Hill's important. The Hill case says,
Evidence show, I thought there was, and correct me if I'm wrong, because as you say, it's a big record, but I thought that there was a part where Schuster goes to the general contractor, Whiting, Turner, and sort of debates, do we have to pay these benefits or not? And sort of persuades Whiting Turner that it doesn't have to pay them. Why isn't that enough to show that they were obviously aware of the benefit? They were lobbying to maintain the benefit.
it shows that Schuster was aware that they didn't have to pay that benefit.
No, it
And if-
shows that Schuster was aware it was getting the benefit, that there was a thing in the world called fringe benefits on overtime hours, and they would prefer not to pay them. And so they got the sign off not to pay them. They obviously knew of the benefit.
The benefit was the services, and it only counts as a benefit, as Judge Schwang noted, if Schuster received the benefit without paying something that it knew it was required to make.
Judge
And
Schwab did
someone,
not say that it was required, that Maryland law would require for knowledge of the benefit that the defendant would have to know it had a legal obligation to pay the benefit.
Judge Schwang, I'm talking about the way that Judge Schwang defined the benefit. I do need to come back to knowledge because it's very important.
Excuse me,
I believe if-
that question, I want to stay on the point that Judge Harris is raising about the benefit. As to whether there was awareness, isn't that simply a jury question as to Mr. Byron or whatever the CEO's name is? Isn't it a question of his credibility? The awareness, is it awareness simply bottoms out on the jury's determination of the CEO's credibility as a factual matter?
If I can, I'm over time. If I could respond very briefly, Your Honor, I don't think it's appropriate to use someone's denial of a fact to be able to then impeach them to prove the counterpositive. I don't think that's appropriate. I believe there's a case from the Fourth Circuit on that called Holt v. Camus, and we would rely on that. And as I'm out of time, I'm going to reserve and return to the point on Hill v. Cross Country Services during rebuttal if the court doesn't have further questions right now. Thank you.
All right. Mr. Pavsner.
Yes, thank you, Your Honor. May it please the court. I'm Steve Pavsner, and I represent Schuster's employees who were the appellees and cross appellants in this case. As appellees, we really can't express our position any better than Judge Schwang did when he denied the appellant's Rule 50B motion and characterized the unjust enrichment claim as a question of whether, in light of all the circumstances, including the parties' reasonable expectations and considerations of fairness and justice, the jury could reasonably conclude, in light of all of those circumstances, that it was unjust for Schuster to obtain a lucrative contract on the condition that it pay its workers state prevailing wage rates and lead its workers to believe that it would pay them on this project in the same way as it would pay as if this were a state prevailing wage project, and then declined to do so. The court below said that there was sufficient evidence to support the verdict, and that as we're here now, Schuster's speaking about the jury instructions and about the admission of this document we call the S3 provide no valid basis whatsoever to overturn the jury's assessment. But the irony here, and I'd like to get right to it because of something my colleague said, we do not start from the proposition that Schuster did not agree to pay fringe benefits on overtime. The notion that there was not an enforceable promise in this case is actually the subject of our cross appeal, because in our view, there was an enforceable promise in this case. In our view, we should have been able to proceed on unjust enrichment in the alternative. Now,
is this really like a conditional cross appeal? I mean, if you were to, I understand you're cross appealing on the wage claim, right, which would require an enforceable promise. If you are right on that, then unjust enrichment goes away, right? You don't win on both.
Absolutely.
Okay.
There's no question about that, Your Honor. And if this court were to allow us to proceed on
This is
the,
like so if this is I think in effect, a conditional cross appeal, like we only reach your cross appeal if you're wrong, if we rule for the defendant.
I think that's a fair way to view
Okay.
it. I think that's a fair way to view it. Clearly, we cannot prevail both on a contract wage claim, on a breach promise, and on unjust enrichment. There's no dispute about that. But here's the thing. Schuster says they did not promise to pay fringe benefits on overtime, but in fact, they did. Not in those precise words, but in different words that mean the same thing. Schuster agreed, and there's no dispute, they say it right in their brief. They agreed to pay their employees scale wages, and they admit that they were required to, and they admit that their employees would have understood from everything they said and did that they were going to pay scale wages. And they also admit in their brief that they agreed to pay the prevailing wages as determined by the Department of Labor. That's at page 53 of their opening brief. The reason they can be required to pay both, as to say scale and the prevailing wages as determined by the Department of Labor, is because that's the same thing. And the testimony below made it perfectly clear that that's the same thing. Schuster's designated corporate representative, Don Wickerser, testified very clearly that Schuster uses the term scale and prevailing wages interchangeably. When they use those terms interchangeably, they're promising their workers that they will pay scale and prevailing wages. So the question then comes down to, what is scale and prevailing wages? Because there's a promise, we're going to pay you scale, we're going to pay prevailing wages. What does that mean? What it means as a matter of law is they are going to pay fringe benefits on overtime, because they admit that they're going to pay the prevailing wages as determined by the Department of Labor, the Commissioner of Labor. And then Mr. Tudor comes in, he's subpoenaed by Schuster. His testimony is both at the deposition stage and at the trial stage.
I thought there was a factual disagreement about how the wages were determined, right? Don't they have some evidence saying that they were going to pay these wages not tied to the statute, but rather because of the contract, because of the parties' agreement?
Yes,
it's not a one-sided record on that.
Well,
is it?
That's where we get to the issue of Schuster's promise to pay as if this were a state-funded project. They agree that they're going to pay the prevailing wages as determined by the Department of Labor. They agree that they're going to pay scale. They agree that those are both the same thing. So then we come to the issue of, what does that mean? What does it mean to pay prevailing wages as determined by the Department of Labor? And that's where Mr. Tudor comes in, who is subpoenaed as a representative of the state. He's in charge of the program that enforces prevailing wage law. And he comes in and says, the Department of Labor has always, at least since he's been there, which is 2010, has always required payment of fringe benefits on overtime. And Schuster itself has paid fringe benefits on overtime when they have performed Davis-Bacon Act projects. Davis-Bacon Act is, of course, the federal law. We have a little Davis-Bacon Act in Maryland. There is no reason, there's no case, no statute, no regulation that suggests that the little Davis-Bacon Act would be construed any differently than the federal Davis-Bacon Act. So Schuster knew that fringe benefits are due on overtime on prevailing wage projects. And when it went to Whiting-Turner to raise this issue of, well, we're not paying fringe benefits on overtime, how did it convince Whiting-Turner to let it slide? The way it convinced Whiting-Turner to let it slide is by showing them an audit from the Department of Labor in 2011. And in that audit, Schuster was dinged, if you will, for not paying the compensation its employees were due. But Schuster was not caught for failing to pay, fringe benefits on overtime on that state project.
What do you say to the statement in the manual that they're not subject to state law regarding the payment of prevailing wages or the Davis-Bacon Act?
I say exactly what Judge Schwang said in the Rule 50B motion.
Okay, what Judge Schwang said at the, it doesn't help
I'm
you.
about to spill the beans on it. What Judge Schwang said was all that means is that this project was not subject to the jurisdiction of the Department of Labor, because the Department of Labor could not enforce it. This project was not subject to the whole statutory scheme of audits and enforcements by the Department of Labor. And that's exactly the way Judge Schwang interpreted that phrase. And it's the only way to harmonize it with everything else that's in this case, in which Schuster is promising to pay the prevailing wage law as determined by the Department of Labor. I mean, that's their opening brief at 53. So all that sentence means is the state can't come in and enforce it. So here's what's important about the state enforcing it or not enforcing it, and Schuster's argument on this point. When they go to White and Turner, they understand that something's happening here. They're not paying fringe benefits on overtime. And White and Turner raises the question. What does Schuster do? Schuster sends them an audit from 2011 in which they're not charged on a state project with failing to pay fringe benefits on overtime. Now, it's very interesting what happened here, because at the summary judgment level, Judge Schwang had that information, but he said, well, he focused on the sentence, this project is not subject to fringe benefits on overtime, excuse me, not subject to prevailing wage law. And he focused on the fact that there was this 2011 audit where Schuster was not dinged for failing to pay fringe benefits on overtime. But what Judge Schwang did not note, and as he should have, viewing the evidence most favorable to us, and he did note later at the 50B motion, is that Mr. Tudor explained that. Mr. Tudor testified that there was an error in the spreadsheet that the Department of Labor was using prior to 2012, that they then caught the error in the spreadsheet and they corrected it. Now, there's no question that testimony was in the record. It was in the record at both stages. But interestingly, my colleague does not mention that at all in their brief. In other words, the Department of Labor testimony in the person of Mr. Tudor was clearly and unequivocally that the Department of Labor has always required the payment of fringe benefits on all hours worked, including overtime.
Why does that matter? I mean, isn't the question what the law requires? So what this Department, of Labor thinks it requires is neither here nor there unless it's something that Maryland courts would defer to. Do Maryland courts defer to PowerPoint presentations by employees?
No, Maryland courts don't defer to PowerPoint presentations per se, but Mr. Tudor testified. This wasn't just somebody who came in and showed a PowerPoint. Mr. Tudor testified that this is the position of the Department of Labor and has always been the position of the Department of Labor. Right. And by the way,
I don't recall seeing a place where it was kind of hinged to, here's a determination that Maryland courts would defer to, right? Here's a regulation, here's how we interpret the statute of language, et cetera. It's not to say he's wrong about how they've applied it, but his opinion is not necessarily the end all be all on what Maryland law requires. It might be highly relevant to the expectation of the parties, right, on unjust enrichment, but maybe not to the legal standard.
Well, first of all, if it were his personal opinion, I would agree with the court. But he is speaking not in his personal capacity. This is not his personal opinion. He was subpoenaed as a representative of the particular program within the Department of Labor that enforces prevailing wage law. And he testified as a representative of the particular program within the Department of Labor that enforces prevailing wage law. And he testified that Maryland law, just like the federal law, just like the Davis-Bacon Act, requires the payment of fringe benefits on all hours worked. So he's not testifying in his personal capacity. And when he shows that slideshow He's going around as a representative of the Department of Labor and teaching employers how to compute overtime. So first of all, he's testifying in his representative capacity. But secondly, federal courts, I respectfully suggest this court, should look to the federal interpretation of the corollary statute. If we look to the Davis-Bacon Act, because this is Maryland's little Davis-Bacon Act, if we look to the Davis-Bacon Act, there's no question that fringe benefits are paid on overtime. Schuster itself admits and admitted in the record that it had paid fringe benefits on overtime in some 14 federal projects. So this court will look, and Maryland courts also will look to federal authority as persuasive, where the statutes are essentially the same. There's no reason to think, based on anything that the state court has said, that the state court would interpret its little Davis-Bacon Act any differently. I mean, why would it? There is no case, there is no statute, there is no regulation that would suggest that the Maryland court would not look to the federal interpretation as persuasive authority. As Mr. Tudor testified, they do. They do. The Department of Labor of Maryland also requires the payment of fringe benefits on overtime. And the only instance that Schuster points to, it's not a case, it's not a statute, it's not a regulation. The only thing Schuster points to suggest the contrary is the fact that once they were audited, they weren't paying fringe benefits on overtime on a state case, and the Department of Labor didn't catch it. Mr. Tudor explained even that. That was an error in a spreadsheet, and regrettably, my colleague does not even mention that in that briefing. That was not the policy of the Department of Labor. Mr. Tudor's testimony was clear and unequivocal that the Department of Labor has always required, always, for as long as Mr. Tudor has been in his position, since 2010, has always required the payment of fringe benefits on overtime. So for those reasons, whether we look at the fact that Schuster is waving around the S3 and posting it in every trailer and saying, we're going to pay these wages, we're going to pay scale, we're going to pay these wage rates, this hourly wage rate, and this fringe benefit rate, that's a promise arising out of the S3 itself to pay fringe benefits on overtime. If I may just conclude 30 seconds, 15 seconds, Your Honor. That's a payment, and the promise to pay scale, which is the equivalent of prevailing wages, which requires fringe benefits on overtime. Thank you.
Thank you, counsel. Mr. Dahl.
Thank you, Your Honor. Your Honor, I'd like to address really one issue, and it is a little bit of a complex issue, but an important issue, because I feel that specifically the Hill v. Cross Country Settlements case may have been misunderstood by the court below and may have been somewhat inaccurately cited in the briefs before this court, specifically as to knowledge or appreciation. On knowledge and appreciation, timing matters. You have to know or appreciate at the time that you have an opportunity to return the benefit.
Don't you even have that opportunity today?
No, Your Honor, because, and Hill solves this problem. They said when the benefit is money, money wasn't conferred to us by the plaintiffs here. There's no requirement that a defendant necessarily have knowledge or appreciation of the benefit for precisely the time the benefit is conferred, because you can give back money anytime. Money is movable. But there's a superscript next to that sentence. It says footnote 12, and footnote 12 solves the problem. Footnote 12 provides a counterexample, which defeats Appley's argument. It cites the classic unjust enrichment case of the house painter who pays the house when the person's away. That's a services contract, and it's a services contract that can't be easily returned. The added value of the home cannot be separated easily and returned to the house painter. Therefore, a court should not permit the house painter to recover. Even though you could pay the house painter, you can't strip off the paint and return the benefit. So too in our case. So knowledge and appreciation only works in this case if whatever Schuster learned, and that's all assuming that what happens in prevailing wage law land matters under the S3 is about timing.
This here is that what Schuster has to have known for knowledge, right, is that it owed this money to the plaintiffs.
No, it said it was receiving benefits without planning to pay the additional money. Otherwise, the house painter example reaches a different conclusion.
So, because one of the arguments in your brief is that the district court improperly failed to instruct the jury that Schuster had to know it owed this money. You are no longer making that argument.
We've made that argument in the brief, but the more salient point on jury instructions for this argument is not the part on element 2, it's the part on element 1, defining the benefit. That's where the confusion arose. Is the benefit the services provided, or is the benefit the money we received from somebody else, or the value we received as a result of the services provided? And Hill footnote 12 solves that problem. It says it's the services provided. You have to have an opportunity to say, whoa, I'm going to blow the whistle, stop work. I have a suspicion that we may owe more money and I'm not willing to pay that money, so stop the work. And there's not sufficient evidence that we learned that in time, because both Amaya and Gonzalez were done on the project by the end of 2015, correct? 2015. Okay. And all of these events that we're looking at now are dated 2016 or later. Okay. Mr. Tudor admitted in his testimony, 4271, that Schuster would not have known following that audit, because he didn't call and tell Schuster that they were doing the law wrong.
I do understand this argument, but this has been helpful to me, sort of clarifying what you're really, which arguments you want to maintain about the jury instructions. Are you still arguing that the district court erred by not or are you arguing that the district court erred by not instructing the jury, as you requested, that unjust enrichment would require bad faith by the defendant? Is that not on the table anymore?
We're going to rest on the papers on that. I have 1 minute and 3 seconds left.
But
Yeah.
it's not in your papers. That's why I'm asking.
Right,
Is that
right.
on appeal or not?
I don't believe it is.
Okay.
I don't believe it is. Regardless, there's a PowerPoint presentation. The testimony was that Lori Burns, the CFO who supposedly attended this, that didn't occur until 2017. That's on pages 4300 of the joint appendix. But both appellees were off the project by that point. That's in their pay stubs, sections, JA pages 5797 to 5820. The knowledge came too late to stop accepting the benefits to these appellees, and therefore it fails element 2, even assuming that what Mr. Tudor believed was the law of the land, even assuming, as I think this court must, that Ms. Burns heard that in 2017, but not until 2017. And therefore, the claim fails under element 2, and this court should reverse under Rule 50. And I'm out of time, and I thank you for your listening to me.
All right, Mr. Posner.
So I'm hearing for the first time that the precise timing of when Schuster learned that it was receiving a benefit unfairly matters. All that it teaches us, this is at page 306 of the opinion, is the quote, the essence of the requirement that the defendant have knowledge or appreciation of the benefit is that the defendant have an opportunity to decline the benefit. They had an opportunity to decline the benefit of getting services without fully paying for them by fully paying for them. The notion that there's some difference between services and money is, I mean, a metaphysical difference, I suppose, but they're flip sides of the same coin. They got services without paying the money. It's the same thing. Clearly, Schuster had the opportunity to decline the benefit by paying the workers after the fact. And it's a small point, but I think it's worth making anyway. My colleague says that Ms. Burns attended this presentation, this slide presentation by the Department of Labor in 2017. In fact, at the record of page 4299 to 4300, Ms. Burns testified that there were workers still on the project when she attended that presentation. And that's 2016. Again, I don't think the months or the year matters. Because as the court indicated or asked, I should say, not to presume what the court's thinking, but as the court asked, couldn't they return the benefit now? And the answer is, of course they could.
Do you want to distinguish the painter when you're painting your house when you're out of town? Hypothetical.
You know, in terms of that as returning a benefit, I think the law in that sort of situation would, as Hill did in some respects, go off on the question of whether the painter was an officious intermeddler. I think that's the way we would have to analyze that, because obviously you don't strip the paint off the house. And if we go back to Hill, we go back to first principles and look at how the Maryland now Supreme Court described unjust enrichment. The question was, is there an opportunity to return the benefit? And is the person who's providing the benefit doing so pursuant to some legal or moral authority? So if the painter, the only way I can distinguish that painter example is the way Hill does, theoretically talking about whether the painter did this as an officious intermeddler, in which case there would be no obligation to decline the benefit, no opportunity to decline the benefit, and no requirement to decline the benefit. So remember the basic facts of Hill, they're a little confusing, but we had a situation in which someone purchases, an owner of a house puts a mortgage on the house, takes a loan out from a bank, and then takes a second loan out from a bank, pays off the first loan. And so that owner then sells, or I think the property descends to the daughter, who's Hill. And for whatever reason, the bank and the settlement company get confused about whether the first loan has been paid off or the second loan has been paid off. And so they report incorrectly to the settlement company that there is no balance due on the loan. When that loan is later discovered, the new owners, by the new owner, his title company pays off the bank and then goes back to the settlement company and says, you guys should have caught this at the time. And so the settlement then ends up suing the new buyer, new owner of the home and the court analyzes that as unjust enrichment and talks about whether there was some moral or legal obligation on the part of the settlement company to pay off the title.
Counsel, let me ask you this. With respect to this second element of unjust enrichment, which was the awareness, is the question of the timing of the awareness, or at what point the awareness came? It seems to me the opposing counsel wants to make that a question of law. And the question that I have is whether the timing of the awareness or when the awareness dawned would be more a factual question. But could you speak to that?
Yes. Number one, I think it's absolutely a factual question. And the way you analyze that factual question is by asking whether there was an opportunity to decline the benefit. And in this case, where what Schuster received was services without full payment, they clearly had the opportunity, even today, to decline the benefit by paying the money. So
all that was argued before the jury, wasn't it?
Yes, all this was presented to the jury.
Everything that we're talking about, I've listened carefully to the argument, but everything that we're talking about, and including when awareness dawned and when there was an opportunity to decline the benefit and everything, all of that was extensively hashed out before the jury, wasn't it?
Absolutely it was, Your Honor. That was the subject of my cross-examination of Lori Burns, talking to her about when she learned that Schuster had received these services without paying fringe benefits on overtime, and when she attended the slideshow and so forth. It absolutely was hashed out.
In many ways, that was the crux of the matter that was submitted to the trier of fact.
It is indeed, and there was more than sufficient evidence for the trier of fact to determine that Schuster had the opportunity to decline the benefit, which meets the second test of unjust enrichment. I just don't want to lose sight, and I see if I can just make one more sentence. I just don't want to lose sight of the fact that there was in fact a promise to pay scale/prevailing wages in this case. And we should have been permitted to proceed in the alternative on that claim. Thank you. I see my time is up. Thank you.
That last point you made goes to the third element, doesn't it?
Whether it was unfair. Yes.
The inequitability of it.
Yes, it goes to inequitability, but it also supports the separate basis that we have for our cross appeal.
I'm not sure you need to get there. It just seemed to me that what you're talking about in terms of the promise to pay scale wages and the like is a crucial element of the inequitability.
I agree with that, Your Honor. The reason we want to get there, if I may, the reason we want to get there is damages. A violation of the Maryland Wage Payment Collection Law carries different and greater damages than we were allowed to recover below. So the reason we're pressing, I mean, just to be perfectly candid, the reason we're pressing the cross appeal is because there's a very substantial difference in the damages.
All right. Thank you very much. If anyone has any further questions, we can keep you up there. Otherwise, we will adjourn court. And we will recede into conference once the courtroom has been cleared.
This honorable court stands adjourned. Sine die, God save the United States and this honorable court.
Let's take a 5-minute break and then resume and have our conference, okay?